Courts of Justice will come to order. Clerk will open the roll. Right.
Mr. Chair, you have a quorum.
Well, thanks. Now that we have a quorum, in case anybody needs to leave a proxy and go to another committee, we'll stand at ease for a minute in order for committee members to proxy in and out of, what is it, Transportation's meeting now?
Transportation's meeting in the cabinet.
Okay. All right, we'll be at ease. All right. We're going to take up a number of bills initially before we get to the patrons who are in line. First of all, we've got a couple that need to be re-referred. Senate Bill 538, Senator Hanger's bill dealing with expansion of courthouses to contiguous properties, needs to go to the Committee on Local Government. Is there a motion to that effect? It's been moved and seconded. All in favor signify by saying aye. All opposed. And I'll remind the members of the committee in the audience, we're going to do a voice vote unless there is a nay vote or anybody asks for it. We'll put it up on the board. Senate Bill 606, Senator Ebbins' bill dealing with the Office of Immigrant Assistance. That needs to be re-referred to the Committee on Rehabilitation and Social Services. Is there a motion to that effect? It's been moved and seconded. All in favor signify by saying aye. All opposed, that's re-referred. Also, Senator Chafin's bill, Senate Bill 776, at the request of the patron, I believe that bill is to be stricken. Senator Chafin moves, Senator Norman seconds. That bill to be stricken. All in favor signify by saying aye. All opposed, that bill is stricken. Finally, Senate Bill 594, Senator Vogel's bill dealing with distracted driving. At the request of the patron, that bill will be going by for the year. Senator Chafin moves, Senator Sturtevant seconds. That motion, I know it's not on the docket, but it is. We're taking it up and taking it by for the year. Any questions? All in favor signify by saying aye. Aye. All opposed. That bill is by for the year. Next, there has been robust discussion over the course of the past several months about some tort reform. There has been a package that has been put forward by the Chamber of Commerce and related entities, and also a corresponding package that was put forward by the trial lawyers and related organizations. And I would say that they have engaged vigorously in efforts to try and bridge the gap and find a way to come to an agreement about best practices and reforms that make good sense, both for the business community, our business environment, and make sure that victims are protected. Unfortunately, haven't been able to reach that consensus. That deadline was given for today. As a consequence, we have five bills that are in this committee. There were, I believe, 7 bills total that were parts of the various packages. And we're going to take up those that are in this committee in block. I would point out that Senate Bill 380, Senator Chafin's bill, was part of that block, and that was taken up on, Monday in Commerce and Labor, and it failed to report on Monday, so that bill has been already disposed of, and there is one remaining bill that deals with the Human Rights Act that is in the General Laws Committee that is part of this group, and it is my expectation that that will meet a similar fate and that the sponsoring organizations agree that that bill, that they will withdraw their support and ask the patron to dispose of that bill. So with that, we have Senate Bills 415, Senator McDougall's, Senate Bill 694 from Senator Deeds, Senate Bill 481, Senator Reeves, Senate Bill 590, Senator Vogel, and Senate Bill 753 from Senator Peake. And I think that given the parameters of the discussion and the understanding by members of this committee, appropriate motion would be to pass these bills by indefinitely or for the year. It's been moved and seconded that these 5 bills be passed by for the year. All in favor signify by saying aye. Aye. All opposed? Those 5 bills are passed by for the year. Next, we're going to address the, bills in order of sign-up. Let's see here. I got nobody in the queue. All right. Sarah McClellan. We have
This is the bill that requires new sentencing hearings for those not,
give us one second.
okay.
This bill, I would point out to the members of the committee, is identical to a bill that was introduced by Senator Wexton last year.
Yes.
Senate Bill 825. So this is not a new bill to the members of the committee, and it reported out of this committee on a 9-6 vote. So with that introduction,
You took
Senator,
half-
go right ahead.
Yeah, you took half of my presentation. I was just going to remind everyone, this is the bill that would require or allow those individuals who were convicted of nonviolent felonies between the time parole was abolished and between the time that the court decision in Fishback versus the Commonwealth came out. Again, you've seen this before, voted on it before, and unless you have any questions, I think it's self-explanatory.
Let me ask you, do you have any idea how many of these people are still in custody at this point in time?
I do have that. It's not very many.
Mr. Chair, I think it's, in the fiscal report, it says 10.
Yes.
All right, thank you. So, and one question that I have, given that the universe of inmates is 10, I mean, is there a reason we need to do this as opposed to relying on the clemency or pardon power of the governor?
Well, I think it's sort of more a matter of just the public policy that there were those individuals who were sentenced under the old rule, who were sentenced and juries didn't know that parole had been abolished, and just sort of the public policy statement that you know, they probably were not sentenced with full information.
And I know this is a question that I had last year, but given that this was 17 years ago that this decision was issued back in June of 2000, how do you ensure that the victims get a fair shake at the resentencing? I mean, is that even possible?
Well, I think for those that want to come and participate in the resentencing hearing, they would be afforded that opportunity to do so. I imagine that the transcripts from the prior sentencing hearings would probably be available, so to the extent they're not available, they're not here today, but they would have been at that prior hearing. Hopefully that would be public record.
But being a trial lawyer myself, or a litigator, I guess trial lawyer, I shouldn't say that, but being a litigator myself, the difference between a transcript and the live testimony of a victim almost contemporaneously, I mean, that's a big difference, isn't it?
It is. I guess there's just sort of a fundamental unfairness of the fact that there were people who were sentenced and juries believed one thing, but something else was true, that just giving an opportunity for juries to have full information.
Senator Norman.
I don't know much about criminal law. When did a victim impact statements, when was that inserted in the code?
I don't know that.
I would suggest to you that it was subsequent to the 2000. And a concern, Mr. Chairman, I would have, if, because of the passage of time, if we were unable to locate and engage the victims, how they would have an opportunity under the impaneling of a new jury to have a victim impact statement.
Mr. Chairman, one thing to bear in mind is that the patron's bill only speaks to felonies that are nonviolent felonies. And so we would not be we would not be denying the victims of crimes of violence an opportunity to be heard.
Okay. Any other questions, patron? Anybody wish to be heard in support of this bill? Anybody wish to be heard in opposition to the bill? Yes, ma'am.
Good afternoon. I'm Theo Stamos. I'm the Commonwealth Attorney for Arlington County and the City of Falls Church. I'm here today on behalf of the Virginia Association of Commonwealth Attorneys, and we do oppose this bill for some of the reasons that Senator Obenshain commented on. And also, if there were to be a resentencing, there's no provision for information to be presented to the jury about the inmates' incarceration period, whether there have been new offenses that have been committed or disciplinary issues. So I think for those reasons and what Senator Obenshain has said, we oppose.
Mr. Chair,
Senator Peterson.
could I ask Theo a question?
Certainly.
If there's only 10 inmates, and as if our counsel said they're nonviolent felonies, you're probably talking about either drug distribution or maybe a financial crime. I mean, would it be that hard to kind of bring the information back in front of a fact finder in this case?
I mean, hard, probably. It depends on how long, it's been. But I think that the concern that we have is the sense of finality. I mean, and the notion that the idea of no parole was even considered or not considered by a jury is speculative. So, I mean, the limited number, I think probably the avenue might be a pardon for that small number. But I also think that if this were to pass, then I think that the jury that's reassembled ought to know and be able to consider a higher penalty if during the period of incarceration that inmate had accrued new offenses, convictions while incarcerated. That happens. The disciplinary record of that inmate should be made known to the jury that sentences. So I think you need to have a transparency issue with that.
All right, thank you.
All right, any other questions?
Mr.
You want to wrap it up?
Yeah, since the snow prevented any folks from coming out today, this is supported by the Virginia NAACP. It's part of their legislative agenda. The resource information help for the disadvantaged and disenfranchised organization, and this is part of the legislative Black Caucus agenda, but snow kept folks away.
All right.
Mr. Chairman, to further answer an earlier question from Senator Norman, we looked up the section for victim impact statement, and the earliest passage date we find is 1983, with various amendments in 1984, 87, 89, 93, 95, and then 96. So it appears to have been in some form always in existence. Another question was whether clemency could serve the same purpose, and I would think not. Because that would put the governor into the unusual position of essentially performing a sentencing function, which is a constitutional trial right for an accused in Virginia. And so I wanted to make sure I made those 2 points.
Senator Norman.
If I could ask Mr. Benjamin, how about a limited pardon?
Well, one form of pardon, of course, Mr. Chairman, is a commutation of sentence. And we do see that on occasion where there has been what appears to be, I think to everyone, a miscarriage of justice, a disproportionate sentence. I don't know that these are good cases for that. And I'll tell you, I think every single one of those 10 have contacted our office for representation. And so I know that they're concerned and feel very strongly about it. We don't do that work, so I have no conflict of interest here.
All right. Anybody else have any questions? With that, the bill's before us. Is there a motion? It's been moved and seconded. The bill be reported. The clerk will open the roll. Who else do I? Oh, yeah. All right. Clerk will close the roll.
Ayes 8, nays 7.
All right. Your
Thank-
bill reports.
Thank you.
And 734.
Yes. 734 is a bill that would provide for the audiovisual recording of custodial interrogations where practicable, but makes clear that failure to make such a recording will not affect the admissibility of any statements made during that interrogation, but that the court can consider and the jury will be instructed that they can consider such failure in weighing the evidence of such statements. The bill also would require the DCJS to establish, publish, and disseminate a model policy or guideline for law enforcement personnel for the recording of custodial investigations, and provide that the length of any interrogation shall not be unreasonable and a person subject to such interrogation shall be permitted reasonable periods for rest and personal necessities such as going to the bathroom. This bill was originally a recommendation of the Innocence Project, that back in 2015. It was drafted in consultation with law enforcement to address the growing concern over false confessions that have led to wrongful convictions. And this year, the Roosevelt Institute at George Mason University, which is a nonpartisan student-run think tank focused on drafting and implementing policy proposals, requested that this bill be put in again this year as part of 10 bills that they sought to have introduced. Between 1989 and 2017, 47 Virginians were exonerated of crimes, and 27 of them, the exonerations were due to, or the original convictions involved false confessions, perjury, or false accusations. And there is a growing concern that particularly among individuals with disabilities, but not exclusively, that sometimes in an interrogation, someone will confess to something they didn't do. And I think the idea behind this bill is, one, to protect the person being interrogated so that someone can sort of view that interrogation in context, but also to protect law enforcement because sometimes accusations are made against law enforcement that a recording would put those allegations in context and sometimes exonerate law enforcement themselves. So I believe the bill is pretty straightforward, but would be happy to answer any questions.
All right, anybody have questions of the patron? I suspect that the Commonwealth's attorneys have some thoughts about this. Unless anybody has any questions at this point in time, let's hear from the Commonwealth's attorneys. Maybe even the sheriffs have some thoughts about this.
Thank you again. I'm Theo Stamos from Arlington County in the City of Falls Church on behalf of VACA. We do oppose this legislation. What it does is essentially codify the notion that police officers are inherently untrustworthy. The problem that we have is the judicial instruction to a jury that unless this has been recorded, you can give minimal weight to the testimony of a police officer that indeed a defendant made an admission to an offense. I mean, the good defense attorneys are using an argument along these lines every day anyway. So we would oppose the codification of that assessment of police officers.
Thank you, Ms. Stamos. Ms. Jones.
Mr. Chairman and members of the committee, I'm John Jones, representing the sheriffs. We do oppose the bill. We think it goes a little bit too far, especially the language on line 247 that it says the interrogation means any interview conducted by a law enforcement officer, and it goes on to talk about it. It just goes too far to accomplish it. We don't have the equipment to do it everywhere. We do understand it should always be done at the sheriff's office, and if we get funding to buy this equipment, we'll take a look at it. But this is out in the field.
All right, thank you very much. Anybody else wish to speak in favor of or in support of or in favor of or in opposition to this bill?
I know there was a student from George Mason who, as of last night, was trying to get here, but I assume the weather kept him away.
I'm sorry about that. Anybody, Steve?
Mr. Chairman, I can tell you that the bill does address a real need in the criminal justice community, and what we have found is that any time that we can record any incident of an arrest or an interrogation, we're rewarded with better accuracy. There's nothing more frustrating than arguing with a client or an officer about what was or was not said during a confession. And it's so much better if we can answer that question with definition. I don't think, and a further value to this is that by recording somebody's statements and their demeanor during the time of a statement, an interrogation, you also capture their mental state at that point, which can be relevant. In any event, I would suggest to the patron that no harm would be done to the bill if the subsection D, which the Commonwealth attorneys spoke to, the instruction that the failure to make a recording, I think if that were deleted, it would do no harm to the spirit of the bill. Moreover, the subsection B, the length of the custodial interrogation shall not be unreasonable. I don't think that really adds anything to what the circumstances would be anyway. I suspect that the real essence of the bill is subsection C, which does not mandate that interrogations be recorded, but only says that if it's practical to do so, you should do that.
Mr. Chair.
I think that's a very good point.
Mr. Chair,
Senator Peterson.
I'm going to make a motion and then speak to it, and I'll say I'm sorry.
Before you do that, my student is here,
Yes.
Andrew Millen, if you'd like to hear from him since he drove all the way
Yeah,
from
you bet,
Fairfax in the
please.
snow.
Yes, sir.
Thank you. Good afternoon. So my name is Andrew Millen. I'm here testifying in favor of this bill. I'm a member of the Roosevelt Institute, which was described earlier. So what this bill does is two things, as have been explained, but first, it recommends interrogations in Virginia be recorded using audiovisual means based on Department of Criminal Justice Services guidelines. Second, it also limits the length of interrogations so those being interviewed can rest and eat, which I think is also a very important part of this bill. And the precedent for this legislation is clear. In 2003, Robert Davis, an 18-year-old from Albemarle County, was convicted of a murder he never committed because he was falsely accused, then coerced into a false confession during a 10-plus hour interrogation in which he could not sleep or eat. And after nearly 12 years in prison, he was exonerated in 2016. His story is not unique either. As was said earlier, 47 Virginians have been exonerated between 1989 and 2017, and 57% of those were because of false confessions. In 2016 alone, 3 of the 4 exonerations were because of false testimony, and the combined time lost between the 3 was 46 years, as well as possibly hundreds of thousands of dollars or more, keeping those innocent people locked up. Every year, there are more and more innocent Virginians found, and many are due to false confessions. So I think this bill is a great first step in increasing accountability, which is voluntary for localities, protects the constitutional rights of those accused, as well as the officers and police departments from costly future lawsuits. Thank you.
Thank you for your efforts and being here. Thank you for your research and your insights on this bill. Appreciate that.
Thank you, Mr. Chair.
Hang on a second.
Yep, I'm sorry.
Before you make a motion, I think there were a couple other questions. Is that okay?
Sure.
Okay. Senator Reeves.
Thank you, Mr. Chair. I just had a question for the patron online.
Any other location which persons are or may be held in detention. So theoretically, that's anywhere. Is that safe to say that would be catching a bad guy coming out of a window on a B&E on a breaking and entering, knowing he's not the resident, coming out, finding out if there's any more people inside the building to which he was burglarizing.
You turn your mic.
My mic's not working. Would I have to?
I'd say the patrol cruiser is more.
I would have to then videotape my conversation with the suspect who's in custody right.
Mr. Chairman, this bill does not include investigative detentions, which is the situation that Senator Reeves is speaking to. Seizes someone who appears to be escaping from or committing a crime. That would be a detention subject to further investigation. In custody refers to the more formal attributes that go along with a formal arrest. And in addition, it wouldn't be practical in the situation that's described, and so this bill would not mandate a recording at that time.
Thank you, Mr. Benjamin.
Any other questions? Senator Peterson.
Yeah. First of all, I want to thank the patron and thank my constituents that came down from George Mason. 2 things I'd like to make a motion, and one is to take out subsection B, which talks about the length of the custodial interrogation not being unreasonable. I'd like to remove that, lines 254 and 255, and then subsection D, which was previously alluded to, which allows a jury instruction where.
Let's do those one at a time.
Separately, okay, then I'll move the, taking out the editing or deletion of subsection B. Make
All
that
right.
motion.
There's a motion. Is there a second? All right, it's been moved and seconded to delete subsection B. Any discussion of that? Any objection?
No.
All right. All in favor signify by saying aye. Aye. All opposed? That amendment is made. Second amendment?
Second Amendment would be the subsection D, which is the jury instruction issue that Commonwealth's Attorney Stamos spoke to, that I think I can see how that would be both confusing and, well, I'll just leave it at that.
Well, let me
So I'd
ask
make that
counsel about that. Well, is there a second to that motion? All right. Let me ask counsel, if we take that out, does that not allow or permit a defendant to challenge the admissibility?
Yeah,
No.
Mr. Chair.
Well, I mean, isn't that part of what D says is shall not affect the admissibility of this statement?
Well, it's saying that, but I don't think even that is necessary. If that causes any qualms, then that could remain in a separate subsection D. The failure to record shall not render a statement inadmissible. There's no harm in leaving that in.
But then what's the statute do?
Well, sorry. Do you want to answer? So you would still have DCJS implementing a model policy. You would still have, where practical, that custodial interrogations would be made, and that the audio, if such an audio-visual recording is made, that it has to be preserved pursuant to Section E. And then you would, if you amend the amendment, such as Mr. Benjamin suggested, you would keep the savings clause that the failure to record would not keep that statement out.
Mr. Chairman, yeah, and I think the patron is right. What this is it doesn't mandate recording. It strongly suggests it. And I think the committee can view this as an aspirational bill, a bill that aspires towards greater accuracy. We all know from present circumstances in Washington that U.S. senators can disagree as to what was said during a particular meeting. By using technology that's available to us, and if an officer has a cell phone, he has the equipment, it promotes accuracy as to what was said or done at any particular point.
Mr. Chair.
Hang on, Senator Stewart.
Senator Peterson, would you consider a friendly amendment to your amendment in subsection D if on line 260, after interrogation, you struck everything after interrogation but left everything in subsection D up to that point?
I'm fine with that.
And then I think it makes it clear.
right.
Steve, do you follow what I suggested? So
Charles, you got it.
subsection D stays in, except you strike everything after interrogation in subsection D.
All right.
But I still have a question. Oh,
Is that
no,
your
no, no.
amendment, Senator Peterson? All right, without objection. All right, Senator Stewart, you had a question? All right. The amendment is before us. Anybody have any questions about what the amendment is? All right, all in favor of the amendment signify by saying aye. All opposed, the amendment is adopted. Senator Stewart.
Mr. Chairman. Senator McClellan, the only question I have is there's a pretty significant body of law on what would lead a reasonable person to believe they were in custody. Sometimes that can be on the side of the road with a vehicle. Sometimes it can be in other places, just depending upon the circumstances. And I'm not even sure I understand all that law, but I've researched a lot of it and dealt with it. And I don't know if I should ask you or Steve or somebody else, but what does this do to that? Does that do anything to convolute it?
Mr. Chairman, Senator Stewart, it does not. The law in Virginia right now is fairly conservative about what constitutes someone being in custody for these purposes. You can be handcuffed, for example, and still not be considered in custody. And this
But
does
not be
change that.
handcuffed and be in custody.
It's fact-specific, but this does not change that.
And Mr. Chair, all I'd add to this is back in 2015, when I first had a version of this bill that did include that same language. That language was drafted in consultation with law enforcement and constitutional law experts, and at the time they were comfortable with the definition of custodial interrogation. So I think they considered that in 2015 and didn't have a problem with it.
Mr. Chairman.
Senator Stewart.
So, Senator McClellan, with these amendments, is it your intent that this bill just be aspirational to try to encourage officers to record as many of these interrogations as possible?
Yes, but if they do record it, I think that the provisions of subsection E are very important, that that recording be preserved until the conditions there are met, and also having the model policy by DCJS, I think, is an opportunity for law enforcement to share best practices. Recording custodial interrogations is very quickly becoming a best practice, and I just sort of want to make sure that that if nothing else, if that policy is made available, I think that might be helpful.
Mr. Chairman. Sorry, I have another, that draws another question. Maybe Senator Northam knows the answer, but are the courts capable?
Going in a different direction, so why don't you finish, sir?
Well, the court's capable of I'm thinking of General District Court. You have a preliminary hearing on a matter and it goes up or not. Are the courts, and maybe we need to hear from the courts, are they capable of preserving this information for this duration? I don't know the answer to that. And I'm not trying to be an impediment, Senator McClellan. I really am thinking through this as we go.
I mean, again, all I can say is when this was first drafted in 2015 and we consulted with the courts, they didn't have an issue at the time. And I have not heard from them since, so.
All right.
Okay, thanks.
Senator Norman.
Senator, I pretend to practice in this area on some occasions, and since 2015, I think from a technology standpoint, there have been some interesting evolutions, and one of the senators just mentioned that technology is available if the officer has a cell phone. But also there has been a terrific enhancement in the use of body cams, which has had a number of consequences. The dash cameras that are there, and I very easily can see myself arguing about the admissibility of a statement in the absence of an officer who had a cell phone, had a dash camera, had a body cam, but just didn't have it on at that moment when the confession or the statements against the interest of the defendant were made, and that causes me to pause.
Mr. Chairman?
Senator McDougal.
It's more than a hypothetical. I can think of an argument recently where two officers responded to a situation after they docked their body cameras and went off duty and made an arrest. And so, but they were still in uniform, displaying a badge authority, marked vehicle. And so would any of the statements made during that encounter then be eliminated? And if they were to be, then that would clearly create some challenges.
Mr. Chairman, I can tell you, I can assure you that those statements would all be admissible. Absolutely, no question.
And I think lines 258 to 260 make that very clear.
All right. With these amendments, the Commonwealth's attorneys and sheriffs have a change of heart? Yay or nay?
Yeah, our big issue was the jury instruction regarding the admissibility of the trustworthiness of the testimony. So if it's the aspirational goal, then we support it. I mean, we love our confessions to be audio taped and videotaped.
All right. John?
No, still don't like it. 249 is my problem with it, Mr. Chairman, if you want me to go into it. It says which a law enforcement officer takes actions.
Got it.
Or asks questions.
Got it.
That could be, hey, I want to talk to you.
Got it.
We got to record it?
Motion, bills before us.
Mr. Chair.
Senator Peterson. Report.
He doesn't technically, from a legal standpoint, have to be in custody. It's if they believe.
Sports team in Northern Virginia, I've talked to certain players who feel like they've been targeted, okay? So this is gonna, once we get these practices out there, this is gonna make things at least more understandable. So I think it's a good idea.
All right, is there a second? Second. All right, it's been moved and seconded the bill be reported. Any further discussion?
Yes, sir.
Senator Norman.
I'm going to vote against the bill for a number of reasons. And I think when we get into criminal law and you start dealing with objective and subjective issues, on line 48, it causes me to pause because of the standard that is created there, and it's a definition, your definition of custodial interrogation. And the standard is, would lead a reasonable person to consider himself to be in custody. A reasonable person perspective might vary significantly between that of the ever astute Mr. Benjamin and Joe Sixpack, who's been stopped on the street.
All right. Clerk will open the roll. The motion is to report.
Ayes 6, noes 9.
All right, the bill fails to report. Thank you
Thank
very
you, Mr.
much.
Chairman.
And before I forget about it, the General Laws Committee may be a little vexed with me because the bill that I asked you to pass by for the year of Senator Vogel's is a bill that's in general laws and is not a distracted driving bill. So is there a motion to reconsider the vote by which we pass by Senate Bill 594 for the year? It's been moved and seconded. Any discussion? All in favor of reconsidering that vote signify by saying aye. All opposed. And the bill that she wanted passed by for the year is Senate Bill 600. Is there a motion to do so? It's been moved and seconded. All in favor of passing by Senate Bill 600 for the year signify by saying aye. All opposed. That bill is passed by for the year. All right, Senator Barker. I think we've got Senate Bill 275.
275, and we do have a substitute for that.
All right, Senator Saslaw moves, Senator Stewart seconds that we adopt the substitute. All in favor signify by saying aye. All opposed, substitute's before us. If you'll give us a second to get it. Rather convenient.
Yes.
Distracted driving.
Yes.
All right, Senator Barker.
Yes, Mr. Chair and members of the committee. This is a distracted driving, basically the hands-free bill. The substitute has adds two exemptions to the four that were listed in the original introduced version of the bill. One of them deals with, was requested by VDOT and deals with the safety service patrols that they have around, that they at various times have to use the handheld devices. And they said that in all the years of using them, they've never had a situation where that resulted in an accident occurring. And in fact, the safety service patrols are occasionally involved in accidents, but nearly always when someone runs off the road and hits a vehicle or something. The second deals with situations when there's a device needs to be used to activate or deactivate something that's installed on the car itself. So those are the two exemptions that are there. What this bill does is basically provides that we would have a hands-free system of driving to minimize distraction. I would point out that last year there was a substantial increase in the number of traffic deaths. I have no idea how many of those were related to distracted driving, but in Virginia we had an increase. I think it was over 100 additional people killed on the roadways, which was an increase of over 10% in terms of, I think it was about 14% increase in traffic deaths. So there are obviously other causes. This is not the only cause that is there, but it's something I think that is would help make a difference if people were operating in hands-free situations. I'd be happy to answer any questions. Maybe.
All right. Yeah, one question.
Sure.
Your substitute, I mean, what are the major changes in the substitute?
The major changes in the substitute are two. One is they are both on the B, which is the provision of this section shall not apply. So there were four things listed originally. What this does is add two other categories. One is number 4, which is the VDOT, Safety Service Patrol Officers who patrol the interstates, those types of things to assist people. They use these in some instances, handheld devices.
Got to keep VDOT happy.
Yes, yeah.
All right.
And then the other is number 6, an operator who activates, deactivates, or initiates a factory-installed feature or function on the vehicle. And some vehicles have things that you activate and control that way.
Okay, so what happens if I've got a cell phone and I watch these ads during the playoffs with like Ford Fusions and the like that automatically sync up with your cell phone? And I mean, it displays data not from the factory installed data, but data from your cell phone on the dashboard. Would it prevent that? Prohibit that?
I do not believe it would prevent that. That's my understanding of part of what they're trying to get at with that number 6 provision.
Number
there.
6.
So, right.
All right, Senator Norman, while I cogitate over that.
Yeah.
Having really started this discussion about distracted driving a number of years ago, I've been interested in the evolution of it. As I drive back and forth now, I see many people going up and down the highway, driving, doing this. And they are not digitally activating anything. They get an incoming call and I say, answer. And so I connect. And then I just start talking. So I'm driving down the interstate, got this phone right up here within the proximity, so my voice is picked up on it. You contemplate that being encompassed with your bill?
That would be encompassed with this bill. I think that what we have now is technology, the Bluetooth and other types of things, so that there are hands-free devices that can allow you to do the same type of thing in terms of having that conversation. And that's what the states that have moved to the hands-free devices basically have been able to achieve there.
Mr. Chair.
Senator Norman.
Isn't that the equivalent of a hands-free device?
Well, it is not quite the equivalent of a hands-free device. I mean, it has some certain similarities to it, but if you're holding that device, it it does limit, means that only one hand can be on the wheel.
Okay.
So
Mr.
there are some.
Chairman, I decide to put my earbuds in and plug it into the phone, and I set that over on the passenger seat.
I'm sorry, I did not.
I'm using earplugs. I put the earplugs, like that little.
He has to pour your
One
ear.
of those
So.
guys on it, but I have, and put the cell phone on the passenger seat.
You put the cell phone on the passenger seat, and then you would not be subject to any violation under this provision. That's correct.
All right. Any other questions, patron, before
Mr.
we
Chair.
open it up for audience?
Mr. Chair.
Senator Peterson.
First of all, is this a secondary or primary offense?
This,
Charles or Steve? Assistance?
It's a primary offense,
That's
Mr.
what I
Chairman.
thought.
All right.
That would be a primary offense here.
Okay, so in other words, anyone that's suspected, reasonably suspected of digitally operating a cell phone or an iPhone could be pulled over with probable cause.
Yes, that would be a primary offense. That's correct.
Okay, second question. You say an operator who is lawfully parked.
Yes.
Let's say you're stuck in traffic. Let's say you're at a stoplight. Are you saying that someone who checks a text or checks that they are now in violation of the law?
I'm afraid so, sir. Yes.
All right.
And you therefore have the basis to pull them over?
Well, they're already pulled over. They're already
Well,
stopped.
really pulled them over.
But
All right. Senator Stewart.
Senator Barker, why isn't this already reckless driving? Why doesn't this already fall under reckless driving?
well, there's been arguments back and forth as to how that's applied now, and part of the concern has been that the section that would be stricken from the existing code, which initially dealt with texting while driving, has been used in many instances to say that therefore it is not reckless driving because there's a separate code. And what this would do is move it into this section, sir. So.
All right. Anybody from the audience wish to speak in favor of this bill? Whoops. Excuse me.
Good afternoon. My name is Dean Gustafson from VDOT, our state operations engineer. I want to thank the senator for taking our amendment and substitute with this bill. VDOT does support the intent of this bill. We'll leave to the General Assembly the methods and means of the criteria, but we certainly support and we appreciate the substitute, including our Safety Service Patrol and other emergency responders in that definition.
All right, thank you very much. Anybody else wish to speak to this bill? Anybody wish to speak in opposition to the bill? Who's that? Senator McDougal.
I'm sure it's well, would my Apple Watch that doesn't have separate wireless capabilities be considered a personal handheld device? So when I look at that, because that's what I can do now every time I get a message.
I would think not, but I don't, I can't tell you for sure, so.
Or I can talk into it too, for that matter.
We can come up with an amendment.
Yeah. That is not handheld if it's on your wrist. The wrist is not necessarily part of the hand, so it's above the joint of the hand, so.
Well,
Read any information.
all right. Is there a motion on the bill? There's been a motion that's been made to pass the bill by indefinitely and seconded. Any discussion? All in favor? Open the roll. Pass the bill by indefinitely.
I don't know how, John.
Somebody have Reeves proxy? All right.
Ayes 9, noes 5.
It's gently passed by.
Thank you very much. I appreciate it. Thanks.
All right. So next, we've got Senator McPike. You've got Senate Bill 645.
Yes, sir. And I believe we have, the committee has similar language from two other senators, Senator McDougal, Senate Bill 403.
Yeah, actually, we're going to take these up. You want to, I think what we're going to do, I'm sorry, I didn't look at my cheat sheet, but we have Senate Bill 403, which is Senator McDougal's, Senate Bill 645, Senator McPike's, and I don't know whether, Senator Peake, you want to be included in this group, or you want yours taken up separately?
I'll take mine up separately.
All right. Senator Norman. You want to, you have a question?
No, I was going to make a comment that I have just finished evolving a bill that's probably filed today, that's going to deal with the situation on the first-time possession of marijuana and the potential disposition of that. And I just offer that by way of information to the chairman, whether or not you might want to defer bills pertaining to marijuana until we can comprehensively address them all, but that's up to the discretion of the chair.
Mr. Chairman, I don't mind deferring because clearly I will be here, but this one does not deal with that particular situation about whether there is an offense or is not an offense. It's only what happens. This is all historical. So somebody's already been convicted or it's already been deferred. So prospectively, how those situations are handled in the future would not impact the universe of individuals that this particular legislation would impact.
This is more broad and different situation.
Mr. Chairman, I would say this is for somebody who has already had a conviction or already had a deferment, not for somebody, I mean, I guess they could get one of those in the future, but regardless of what the committee decides, I don't think that will negatively impact the trajectory.
Yeah, let's go ahead with the bills now.
But I'm happy to wait because we'll be here.
I think we'll, let's go ahead.
Mr. Chairman, this was a bill that I introduced last year at over a period of 2 years in my area. There was lots of conversations with a tremendous number of different community groups who had a wide range of perspectives. As the committee knows, my perspective I used to be a prosecutor. That's how I started in my legal career, have done defense work as well, in addition to what we do here. And a situation that occurs repeatedly, more so now than what it used to, is an individual who, while they were in college or right out of high school, when they turned 18, 19, 20, obtained a possession of alcohol, they got arrested, and that arrest is now recorded in the criminal information data bank. So they go to get residency at a hospital because they passed their medical boards, or go to work at a Fortune 500 company. That hits, they lose that residency, they lose that job. There's no vehicle in the Commonwealth for that person to get redress. So this is very narrow, it's very focused, and some people may have a larger focus, but the narrow focus is possession of alcohol, possession of marijuana, either conviction or deferment, and you're under 21. You could be expunged. But, Mr. Chairman, one of the reasons I'm back before you in this committee, and Senator McPike is here, is because when it left here, the issue is Virginia has never done an expungement for fact sufficient or a finding of guilt. And so it is a different policy direction for the Commonwealth.
And I would note for members of the committee, the historical component, that this is identical to your bill from last year, which passed out of this committee 12-0. And Senator McPike, you want to add anything?
No, Mr. Chairman.
And I would add
conform to-
that one additional benefit of this is that I have a certain circuit court deputy clerk who, every time somebody calls her wondering why their child can't get into nursing school because they have that possession of alcohol charge that they can't get expunged, she gives them my telephone number and tells them to call me. And I remind her that I voted for this last year and I will vote for this again this year. And so with that, anybody in the audience feel compelled to speak in connection with this bill? The state police does.
Mr. Chairman, I don't know that they're going to come up with some great enthusiasm in support of this.
Mr. Chairman, Keenan Hook with the State Police. We do not lack any enthusiasm for this bill. We simply request, we have it in our pipeline to program the changes that will allow us to expunge arrests into the criminal history database. Right now, we cannot do that. We would ask for a delayed implementation date to January so that we can have the time to make that program change.
That seems like a very reasonable request. Ms. Stamos, you have similarly reasonable requests?
Always reasonable, Senator. We do oppose the sea change that, expungements are reserved for those who are truly innocent. We are concerned about the access to the database in order to use it as a predicate offense. And I think there's also an issue with the Class 1 misdemeanor for those who ask the question about those convictions. So we have a problem with that.
All right. Senator McDougall, you want to offer that amendment with
I would,
delayed
Mr. Chair.
enactment?
Yes, January 1 of 2019.
Senator McDougall moves and Senator Stewart seconds the amendment. All in favor of the amendment signify by saying aye. All opposed, the amendment is adopted. Any further discussion? Bill's before us.
Just the housekeeping.
All right, it's been moved and seconded that the bill be reported and re-referred to Committee on Finance.
Mr. Chairman, did Senator McPike's bill get rolled in as a chief co-patron?
All right, is your motion to roll the bills together and report and re-refer the two bills under Senate Bill 403, report and re-refer the Committee on Finance? Is that your motion, Senator Sasslaw? Yes. All right, it's been moved and seconded. All in favor signify by saying aye. Go ahead and vote. Yep. All right.
Ayes 15-0.
All right. Next, we've
Mr.
got...
Chairman, I asked Secretary Moran if he would come up and speak in favor, but he was concerned that his status as a Patriots fan might be detrimental to the passage of the bill.
All right. You have another bill,
sir? Yes, Mr. Chairman. Senate Bill 653.
Oh, yes.
This is a bill that the committee is familiar with. It deals with the code section of carrying dangerous weapons into a religious place of worship. Part of the issue with the current code section 18.2-283, it states that if any person carrying any gun, pistol, bowie knife, dagger, or other dangerous weapon without good and sufficient reason to a place of worship while meeting for religious purposes is being held, he shall be guilty of a class 4 misdemeanor. And this came up before the committee last year. It is also a bill that is in a different posture than my friend Senator Chafin, which I think gets to some of the heart. My bill addresses it a little bit differently, which is to take out in the code section without good and sufficient reason and put in the affirmative the power to our clergy. This is an issue that continues to be a concern in terms of religious places of worship security. I know our Virginia State Police have done outreach this year, in fact, on how to improve it. So this addresses a little bit differently than Senator Chafin's,
All right.
but I appreciate the language as well.
Well, let me put a finer point on that. I mean, Senator Chafin repeals this code section, and this bill, you introduced this bill last year.
Yes, Mr. Chairman.
And this bill was heard in this committee and passed by indefinitely on a 9-6 vote last year. How does a place of worship give express authorization? Let me just strike that, forget it. Anybody have any other questions of the patron? All right. Does anybody feel compelled to come up and speak? All right.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. My membership supports this bill.
Supports the bill,
Yes,
okay.
we
Let's
think
hear
it
from the
clarifies
other
the
supporters.
Support.
Okay, yes, sir.
Mr. Chairman, Josh Hortz, Educational Fund to Stop Gun Violence. We support the bill, and I will, not speaking for my particular house of worship, but I will say that we have a sophisticated security presence, and I think it gives the houses of worship the chance to develop the program the way they want to.
And, okay, yes, sir. Yes, ma'am.
Mr. Chairman, Felicia Preisner with the Virginia Catholic Conference. We do support this bill. The Virginia Diocese wish to maintain the current default presumption that firearms or other weapons are not allowed at places of worship.
All right.
With the ability to apply that express authorization.
Okay. Anybody else in support of this bill? All right, let's hear from opposition.
Mr. Chairman, ladies and gentlemen, Bob Sadler, Virginia Citizens Defense League. We do oppose this bill. However, I would like to thank Senator McPike for a bill which is relatively restrained compared to what is coming from the Attorney General. Our problem with this bill is that it is much easier for a pastor to simply opt out and hang a sign in the door. Every church in the Commonwealth is free to ban guns at their will. To have to pass out written authorization to each individual congregant is much more work than what we simply have now. We have a coalition of faith leaders. I believe Senator Chafin has a coalition of faith leaders, and we would like things to go Senator Chafin's way. Thank you.
Thank you very much. Yes, sir.
Eddie Ayla, Virginia Assembly Independent Baptist. I'm actually not super opposed to his bill because it does fix the problem that we had with that language. But our preference is Senator Chafin's bill.
It's an improvement from last year.
But it is an improvement, and I do appreciate somebody trying to fix that issue.
All right.
So I appreciate it in that respect.
All right. Anybody have any other comments?
Mr.
All
Chair.
right, Senator Peterson.
Seeing how Senator Chafin's bill, I assume, is mutually exclusive but drawn to the same code section?
It deletes it.
Oh, it just deletes the code
It deletes
section?
the entire code section.
Well, that would be mutually exclusive.
No, we
Are
cannot
we taking them
pass
both up at the same time? Or?
No.
We'll have a
Well,
motion to help that.
Well, whichever passes last, I guess, is.
Okay.
Rock, paper, scissors.
All right. Bills before us.
Substitute motion passed by indefinitely.
It's been moved to report. It's been seconded. Substitute motion is to pass bill by indefinitely. Is there a second to the substitute motion? It's been moved and seconded. Substitute motion is before us. Clerk will open the roll on the motion to pass the bill by indefinitely. Clerk, close the roll.
Ayes 10, noes 4, abstention 1.
All right. All right. Senator Norman moves.
Mr. Chairman, having voted on the prevailing side, I'd ask that we reconsider the vote by which the bill was defeated, sir.
Is there a second to that? All those in favor of reconsidering the vote by which that was passed by indefinitely signify by saying aye. All opposed. Bill is before us on the motion to pass the bill by indefinitely. Open the roll. Close roll.
Ayes 9, noes 5, abstentions 1.
All right.
Thank you, Mr. Chairman.
Yes, sir.
Thank you, Mr. Peterson, Senator Peterson, for the privilege to hit it twice, so.
All right, next we've got Senator Carrico, not here. Senator Sproul.
Thank you, Mr. Chairman. First, Mr. Chairman, you have.
Senate Bill 24.
Yes, sir, you have 742. I ask you to strike that, remove that one.
Oh, we can do that. Senate Bill
742.
742. Senator Stewart moves. Senator Sasslaw seconds. Striking 742. All in favor, signify by saying aye. All opposed. That bill is stricken. Let's go to Senate Bill 24.
Thank you, Mr. Chairman. I have an amendment in this for substitute, Chairman.
All right. Senator Sproul, Senator Cosgrove has the identical bill.
Yes, sir.
And I mean no harm. He indicated to me today that the city of Chesapeake wanted to send somebody up and to testify, but that because of weather they were unable to get here. I'm happy to take them both up, or you can present and we can postpone a vote. Do you want to do this, or you want to wait for your city to be here?
Mr. Chairman, I was hoping that I talked to the city of Chesapeake today. Their concern was the changes that were made. I don't know whether John have them or not, but if he had the changes, I assume if he had the substitute.
I think he indicated that the chief of police wanted to be here to testify in support of this.
All right.
And was planning on traveling up, and as an accommodation to him, I told him, sure, I'd be happy.
Right.
And I know you've been sitting here, so I'd be more than happy to, for you to make your presentation, and we can come back and do it on Monday. But
That'd be fine.
or we can just do it on Monday.
Would it be Monday, not Monday morning though, right?
Yeah, bright and spanking early. We're usually here till about 11 or 11:30.
I can make it by that time, yes, sir.
We don't want to get you up too early.
Yes, sir. All right, that'd be, Mr. Chairman, if you could say that not put it on the agenda until after 9:30, I would appreciate it. I leave home Monday mornings.
If you want to leave your telephone number, we'll give you a wake-up call real early.
Yes,
I
thank you
think
so
maybe
much,
we're
Mr.
going to
Chairman.
start taking reservations.
Thank you, it'll be fine.
And I'm sorry.
All right, yes, sir. Thank you, Mr. Chairman.
All right. Next, we've got Senator Wexton, Senator Marsden, Senator Carrico. We've got members of the committee who have bills. Senator Chafin, you want to do 372?
Mr. Chairman.
I'm sorry.
I have some
Senator
housekeeping
Stanley.
if you want. Can take care of the one that I have, Senate Bill 167. It's the
You jumping
discovery.
in front of Senator Chafin?
Well, this will take 2 seconds.
All right.
So, Mr. Chairman,
All
members
right, we've got Senate Bill 167.
Mr. Chairman, members of the committee, if you remember, this is the Discovery Reform Bill for criminal defense and criminal justice. After last year, when this bill sailed out of the Senate 39 to Obenshain, it died a death in House crimps up, which is so shocking.
I was prescient.
Yes, and but the state bar put together a panel chaired by Judge Humphreys from the Virginia Court of Appeals, and I'd met with him during VCJC's weekend, and then he and I had a discussion. He has sent to me a consensus change in the Supreme Court rules, which captures a lot of what we're doing in this discovery reform bill. And it's really very impressive what that commission did. And so that goes before the Supreme Court for approval in April. And I am hopeful that if they get it approved, which they may not, but I gave Judge Humphreys my word, that I would carry this bill over for this year, and I will bring it back if the Supreme Court fails to act next year, or this year. I will bring it back next year. And as I told him to tell them, if the Supreme Court fails to act, then the legislature, I think, will be forced to act. So for those reasons, I'd ask that this bill be carried over and be made into the form of an anvil, which sits gently over the top of those that consider Judge Humphreys' good work.
That's very bold, I would say.
A paper anvil.
So your motion is to pass the bill by indefinitely?
To carry it over till tomorrow, till next year.
All right.
Carry it over.
All right. Is there a second? All right, it's been moved and seconded to carry the bill over for the year. All in favor signify by saying aye.
Aye.
All opposed, the bill's carried over for the year. Senator Chafin? You do not. Not right now, you don't. Senate Bill 372.
Thank you, Mr. Chairman. This legislation, as the body just looked at a moment ago, it repeals the code section that has been on the books for a long time, and really it's a property right. It's a recognition of a property right. Churches are not owned by the government. They are not owned. They are not publicly owned. They are private property, and they are owned by the organization that has invested its money or had the property donated by the members of the church who organized and who have invested their money to build a sanctuary, to build a church, a place, a house of worship. And this bill simply seeks to recognize the fact that places of worship should be able to have the policies, just as you and I have, about whether or not to allow firearms, or whether or not to allow their house of worship to be defended. That's really what it boils down to, whether or not to allow for people to defend themselves in a house of worship. We all know, we don't have blinders on, we all know what's going on in the world out there, and how that people are being hideously murdered in places of worship. Almost an entire town was killed, a small town out in Texas, while they were in their sanctuary. And so, bottom line, it's a property rights bill. I mean, it just simply recognizes the property rights of those members, and I hope it will be the pleasure of this committee to pass it. And I also hope it will be the pleasure of our governor for him to recognize with his moral compass that people all across the Commonwealth want to worship and be in a sanctuary safe from harm.
All right. Thank you. Anybody have any questions to the patron?
I'd just make a comment.
Senator Norman.
I'd say, Senator Chafin, knowing a little bit about compasses, sometimes the azimuth gets thrown off by the proximity of metal.
I do know that sometimes that
All right.
can happen.
We're going to hear from those in support of this piece of legislation.
Eddie Edel, Virginia Assembly Independent Baptist, holding to the views that Senator Chafin is, that we are private institutions. Thank you.
Thank you.
Philip Van Cleve, President of the Virginia Citizens Defense League. Yes, we strongly support this. The churches can still ban guns, Class 1 misdemeanor, which is a stronger misdemeanor than this bill has. The state shouldn't be telling churches how to do security. And we have quite a coalition within a few hours of asking members if they were church leaders that they would be in favor of this. We had 50 of them in no time flat signing on that were pastors, deacons, priests. So we support the bill. Thank the senator for putting it in.
Aaron Looper, the National Rifle Association, and we thank the senator for putting this bill in. We absolutely support it and don't think that somebody's constitutional right to protect themselves should be stripped based on their decision to worship.
All right, thank you. Anybody else wish to speak in favor of the bill? Anybody wish to speak in opposition to the bill?
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We oppose the bill because this sends out the message that it is decriminalizing that carry in church.
All right, thank you. Oh, sorry.
Mr. Chairman, Educational Fund to Stop Gun Violence opposes the bill.
Thank you.
Mr. Chairman, Felicia with the Virginia Catholic Conference. The two dioceses in Virginia do oppose this bill. We do wish to maintain the current default presumption that firearms and other weapons are not allowed at places of worship.
Okay, thank you very much. Anybody else wish to speak in opposition to the bill?
The administration would oppose the bill as well.
All right, thank you very much. Anybody else? Bill is before us. Is there a
Move to
motion?
report.
All right, it's been moved and seconded the bill be reported. Open the roll.
Ayes 9, noes 6.
Thank you, Mr.
All right.
Chairman.
Yes,
This
sir.
bill, I do want to say to you, this bill was brought to me by faith leaders in my community. It was not brought to me by any politically active organization.
All right, next we've got, thank you. Next we've got Senator Wexton. Senator Wexton, you've got Senate Bill 434.
Thank you, Mr. Chairman.
And this bill deals with restoration of rights
That's
for
correct, Mr.
convicted
Chairman.
felons. This is the same as the substitute that was offered last year, 1464, which failed in committee on a 3-12 vote.
I'm not sure, Mr. Chairman, that it is the same substitute.
Am I
There's
right?
a different one.
Huh? Oh, a new substitute. Okay.
There is.
Ah,
New and improved, but inspired by the original.
thanks for pointing that out. All right. Senator Stewart moves, Senator Sasslaw seconds the adoption of the substitute. All in favor of adopting the substitute signify by saying aye. All opposed. Substitutes before us. Senator Wexton, go right ahead.
Thank you, Mr. Chairman. As the members of this committee are aware, our previous governor was very active in restoring the civil right to vote to a number of convicted felons. And there is a reasonable likelihood that at least some of those folks are going to want to also have their firearms rights restored. And that has drawn attention to the fact that our current system really does not have any sort of standardized evidence-based criteria to identify those individuals who may pose an elevated risk of violence. So venue for these restoration proceedings lies in the locality where the person resides, or if they are not from Virginia, in the locality where they had where the conviction had taken place. So we're going to end up in a situation where there's circuit court judges all around the Commonwealth not applying standardized factors, not applying any sort of evidence-based factors in determining who should get their rights restored. So this substitute calls for various factors that the court shall consider. There's a 15-year waiting period. Data on recidivism shows that the risk of committing a new crime decreases the longer the individual's been out of prison. And at 15 years, somebody who has been released from confinement or the time of conviction is the same risk pool as somebody who has never offended before.
So, and let me ask you, I apologize for interrupting. So right now, and whether you can answer this or counsel, right now, how long does a formerly convicted felon have to wait in order to ask to have their firearm rights restored?
My understanding, Mr. Chairman, is that nobody can petition until their civil rights are restored.
Okay.
So that would be the triggering, no pun intended, event.
So this means, I'm sorry, rights restoration plus 15 years?
This would be 15 years after the date of conviction or release from confinement or
So
supervision.
if somebody is convicted of a felony, let's say felony shoplifting, and gets a felony conviction but a suspended sentence and gets their rights restored, they wouldn't be eligible to get their firearm rights restored for 15 years.
That's correct.
Wow, okay. Second of all, this also, does it change the standard for judges to restore the rights from current law?
Mr. Chairman, that's a good question because there really is no standard right now. So
Well,
this
let me
would.
ask counsel, I thought that the standard was good cause. Am I correct?
I think that is correct, Mr. Chairman.
Okay, so this changes it from good cause to what?
No, just
Lines 58 and 59.
It is
clear and
It is clear
convincing.
and convincing, and there are other factors that the court that shall consider in making that
The
determination.
good cause
that-
standard is at 61, Mr. Chairman.
I'm sorry, yeah. So that shoplifting felon would have to present clear and convincing evidence 15 years later as to why he should or she should have their firearm rights restored.
Why he or she is not a substantial risk of injury
Okay.
to the public or danger to the public, yes.
And do you think that that shoplifting felons ought to bear that, that scarlet letter that they are risk to the community?
Mr. Chairman, the 15 years is where the data show that people are no longer at the same risk, that they are back in the same risk pool as people who have never offended.
So do you think that shoplifting felons are a risk of violence to their community?
Mr. Chairman, that's something that would have to be considered by the court after the period has elapsed.
Wow. All right, Senator Norman and Senator Chafin.
Senator Waxman, just so I'm clear, under this provision, you would not have to have your rights restored.
Mr. Chairman, you do have to have your rights restored. You'll see on line 54 that you cannot file a petition for a permit unless the civil rights have been restored by the governor. That's existing law. Unchanged.
Right.
Thank you.
All right, Senator Chafin, hang on. Let's do this one at a time.
Senator Wexton, under this bill, so this bill takes away the discretion of the circuit court to act in a petition the way that it's been done for, forever, 50 years, 70 years, right? Is that right?
Mr. Chairman, Senator Chafin, it does not take away their discretion. It just gives them factors that must be considered in a timeline after which they would be able to make those considerations.
Right, Mr. Chairman.
Senator Chafin.
But after giving back their rights, after the push that the previous administration had to give back the rights of felons, what this bill essentially does is that for a period of 15 years, it will keep them as second-class citizens. Isn't that right?
Mr. Chairman, Senator Chafin, absolutely not. It would not make them second-class citizens, but the 15-year period would have to elapse from the date of their last conviction. And so a lot of the folks who had their civil right to vote restored would still be able to petition tomorrow.
Senator Chafin.
But would it not be true to say that right now, if they've paid their debt to society, if they've had their civil rights restored, they can petition immediately, and a circuit court judge who determines that due cause has been met, that standard's been met, they can get their gun rights, can't they?
Mr. Chairman, Senator Chafin, that is existing law.
Yes. And the main, Mr. Chairman? Mr. Chairman.
Senator
The
Chafin.
main emphasis of this bill is to impose a 15-year barrier to keep them gunless, isn't it?
Mr. Chairman, Senator Chafin, that is not the main purpose of this bill. The main purpose of this bill is to ensure that evidence-based criteria are used in making those determinations and that there are standardized factors that all courts throughout the Commonwealth consider.
Mr. Chairman. Mr. Chairman. One final question. Then why don't you strike the 15 years from your bill? If that's not the main reason for your bill to keep people from having firearms after they've been convicted of a felony, why don't you strike that part of it?
Mr. Chairman, Senator Chafin, the 15 years is, the data show that that is the period at which folks are at in the same risk pool as people who have never offended. And that is why it's in there.
Mr. Chair.
Hang on. So that shoplifting felon who's got a stalker who has physically assaulted them, they can't, that shoplifting felon is not even eligible for 15 years to go to the judge to seek firearm rights to protect herself.
The bill provides for 15 years from the date of last conviction.
Yeah, okay. Senator McDougal.
Mr. Chairman, I, just as I look at the restoration, I think many of us feel that a blanket restoration for every individual, regardless of the offense or regardless of the time of the offense, was not the best direction to go. So right now, we have people out who are been determined to be a danger to the community. Some of them have been determined to be still sexually violent predators. And because of the governor's action, they have the ability to serve on a jury, even in cases where individuals are alleged to have violated children. Immediately, same day, the governor issues the order, they can be on the jury. But yet we have people who have had nonviolent offenses, which we talked about the larceny threshold here last week, and then we want to take a constitutional right and put a 15-year look back. There is a logical direction for us to work in the restoration of rights. And that logical direction is to talk about violent felonies versus nonviolent felonies. And this bill does not do anything to do that. And Mr. Chairman, until we deal with the issue of violent felons, individuals who have committed some heinous offenses, murder, rape, robbery, arson, pedophilia, we're letting every one of those individuals have the same rights restored. We need to address that issue before we can get to the other issues.
Okay. Senator Saslaw.
What I was going to suggest is have the bill put in a form where it differentiates between people who've committed been convicted of violent felonies versus nonviolent. The $500 or $1,000 shoplifter that Senator Obenshain talked about, I don't think should have to wait as long as the guy who, has pulled off, a half dozen armed robberies before they finally caught him. And you might want to consider an amendment that deals with that as opposed to lumping everybody into the same category.
Mr. Chairman,
Right,
Senator Saslaw, I would not object to such an amendment, but any amendment I think would require that that it be driven by the data and by the recidivism
Trying
data.
to help you, Senator.
No, I appreciate
Senator
it.
Stewart.
And I just don't have that information in
And I
front
haven't
of
looked
me in
at
order
this
to make that
statute
amendment.
for a while, but my recollection is there is already a process to do this. And I guess the impetus for this bill is this blanket restoration that was done by the governor. And so now you have all these folks who had their rights restored and they're going to be applying for guns, and you want to put an impediment to that. But here's why you don't want to do that. Because good people get caught up in that. I was a prosecutor, and I saw more than one poor person who had a felony bad check from 3 or 4 or 5 or 6 years ago who really didn't know any better would buy a shotgun to go deer hunting. And they'd be out there deer hunting, and the game warden would come along and check them, check their license. They'd find out they were a convicted felon. And they got a shotgun in their hand deer hunting. They're not up to anything malicious. They didn't even have any idea they were breaking the law. It's a 2-year minimum mandatory prison sentence. And it's actually 5 years under federal law if they were caught by game and fish and wildlife. And so when you do something like this, and I understand why you're doing it, but you're going to catch up a whole lot of good people who don't deserve to be caught up in this. And so, Mr. Chairman, I'd move to PB out of the bill.
Second. All right, it's been moved and seconded to pass the bill by indefinitely. Any further discussion? Hearing none.
Mr. Chair.
Senator Peterson.
I just want everyone to realize that under U.S. Code 18, Section 922, felon in possession is already a felony under federal law. And I've never understood for the life of me, we had this debate. If you're walking around, if you're a convicted felon and you're walking around with a firearm, you get picked up by a federal agent, you're doing time, okay? So, this is kind of an academic discussion. I understand all the comments that have been made, but it's the federal law is what's really going to sweep people up. And I don't know if anyone's talking about that, but anyways.
All right, there's a motion to pass bill by indefinitely. Clerk will open the roll. All right. Clerk will close the roll.
Ayes 12, noes 2.
All right.
Thank you,
Senator,
Mr.
thank you
Chairman.
very much. And next, we've got Senator Marsden.
Yes.
Senate Bill 96.
Could we start with 811? Would that be okay?
What's the matter
Well,
with
we
96?
can start with 96. Yeah, that'd be fine.
All right. Senate Bill 96.
Thank you, Mr. Chairman. What this bill attempts to do is to merely reflect the intent and the language that the Supreme Court has used in the Roper, Miller, Graham decisions about making sure that that judges and parole boards consider those decisions in making either sentencing or parole decisions for those who were sentenced and transferred, or excuse me, who were transferred as juveniles to the adult court and sentenced. And the reason for the bill is that under Virginia statute, in the situation of a homicide, a capital offense, execution has been taken off the table, and the only sentence can be life without parole, which has been ruled in those cases as in the Miller situation, is that even in those situations, you must consider some mitigating circumstances and the unique nature of the capacity of a child to change and their somewhat diminished capacity as a juvenile. And what we want to make sure here is that judges do not bypass a sentencing hearing, which sets up a route of appeal that we would not necessarily want. And there are still young people eligible for parole, and reminding the parole board of these rulings is the intent of the bill, to remind the judges and remind the parole board of what the Supreme Court has said in these matters, so that they're procedurally correct as they move forward.
Senator Marsden, and I don't know whether you can answer this or whether this is more appropriately a question for counsel, but I mean, what you just said was that you want to seek to make sure that judges correctly sentence. I mean, isn't that what we ask judges to do anyway, is to follow constitutional guidelines and procedures? And I mean, is it going to be possible to codify every parameter of every constitutional issue that's addressed by the Supreme Court? And I know I appreciate what you're trying to do, but I question whether this is something that's practical, or whether this is what we already asked judges to do.
Yield to counsel.
Mr. Chairman, I think the answer is that there is not presently a constitutional requirement that courts consider these factors in sentencing juveniles. And so I suspect that the patron's concern is that when you have a juvenile who has committed an offense which would be truly terrible and heinous if committed by an adult, it's still terrible and heinous committed by a juvenile, but perhaps a judge needs, the judicial system, the juvenile justice system might benefit from the General Assembly statutorily requiring that a court consider these factors that might otherwise be a little counterintuitive. The judges may feel that they have got to sentence juveniles who commit these atrocious offenses to the same terms that they would sentence an adult, and may find solace or perhaps guidance if it comes from the General Assembly.
aren't they required to consider all relevant factors? And as a defense lawyer, if you're representing a youthful offender, don't you every time argue youthfulness?
Oh, sure I do. But it's one thing for me to argue it, and another thing for a juvenile court judge to feel, or a circuit court judge sentencing a juvenile as an adult to take into recognition these factors.
Right. Anybody have any other questions?
Mr. Chairman,
Senator Peake.
I have a question to Senator Morrison and ask if you would consider changing the shall in line 60 and line 32, I believe, or line 30. It's 31, 32 and 60. If you change those to may, and ask Council Benjamin if that would affect the statute.
Yield to counsel.
I don't think it does any harm to make that change.
I would accept that as a friendly amendment, Mr. Chairman.
You make that amendment?
Please.
I'd like to make that amendment.
Senator Peake moves. Is there a second to that amendment? It's been moved and seconded. All in favor of adopting that amendment, signify by saying aye. Aye. All opposed, that amendment's adopted. Anything else? Senator Marsden, you want to yield to anybody who wishes to speak in favor of the bill?
Mr. Chairman, Theo Stamos with VACA. We do support this legislation.
Okay. Anybody else want to speak in support? Anybody want to speak in opposition? Any questions? Bill's before us. It's been moved and seconded. The bill be reported as amended. Clerk will open the roll. Congratulations.
Thank you, Mr. Chairman, members of the committee.
Now, next, we've got Senate Bill 99.
Okay. Getting tougher here.
We want to hear about the problems at Tyson's Corner with hunting dogs being released on highways.
And it is a significant problem, but
we down here in rural Virginia would like to know what kind of problems you're having up there.
Yeah, Mr. Chairman, ever since I did that fox penning bill, which I think was of concern to all Virginians, my rural colleagues in the House of Delegates and some members to some extent in the Senate have expressed some of their concerns about these problems and the difficulty of solving them. What this bill attempts to deal with is the problem of dogs repeatedly and with impunity trespassing on lands in which their owner has not granted permission to hunt, and it's rampant throughout rural Virginia, and it's dividing communities and setting people at each other. I've received numerous emails, letters, and phone calls from landowners who are at their wits' end. Many of these landowners are hunters themselves. The purpose of this bill is to provide some assurance that dogs will be released on or adjacent to land where they are authorized to begin to hunt. While I understand that dogs will often go where they are not allowed, there are numerous poorly behaved hunt clubs and dog owners who do not particularly care whose land they trespass on and disturb the peace, tranquility, and the right of property owners to enjoy their property. I've also received reports of confrontations between landowners and deerhound hunters who repeatedly let dogs onto posted property because they have the right to retrieve. So this bill would reduce the number of deerhound hunters from releasing dogs wherein they would be immediately trespassing by creating a Class 3 misdemeanor for releasing deerhounds on public roads or within 15 feet of either side of that road. We could reduce the volume of trespassing incidents and ensure that more deerhound hunters obtain permission to hunt from lands where their dogs are released. The bill provides an exception to releasing dogs on highways if the deerhound hunter has the permission to hunt on land adjacent to the place on the road that the dog is being released. So if in other words, you do not have to penetrate the property, you can pull up on that road and release your dogs into the adjacent woods, and you would be in compliance with the law. The bill creates a Class 3 misdemeanor for a first offense and a Class 1 misdemeanor for any substantive offenses.
Mr. Chair, I think he was addressing the substitute, and
I'm sorry.
Senator
Deeds moves. Senator Stewart seconds the adoption of the substitute. All in favor, signify by saying aye. All opposed, the substitute's before us. Anybody have any
Mr. Chair.
questions of the patron? Senator Reeves.
So this says releases. What if I stop Senator Marston on the side of the road to pick up my dogs at the end of the hunt?
That's not releasing your dogs, that's picking your dogs up.
So, further question, Mr. Chairman. So how does a game warden or whoever's going to enforce this know if I'm picking them up or letting them out?
I think that would require evidentiary witnessing of the event and being able to convince a magistrate or a jury or a judge that that is indeed the violation of the law. But I think dogs getting onto the truck is different than dogs getting off the truck.
You think? Okay.
That much I do know about.
All right. Anybody have any other questions of patron? Anybody wish to speak in favor of this fine piece of legislation?
Good afternoon, committee. Chairman Obershane. My name's Aaron Baumgartner. I'm a landowner in Southampton County, Virginia. I reside in Richmond here in Bon Air. I bought a farm 5 years ago, 150 acres. And to say that things are rampant is an understatement. Absolute understatement. I am a lifelong deer hunter. I am a lifelong sportsman. And I am flat out embarrassed by what I've seen. I filed 18 complaints this past deer season. Deer dogs trespassing on my farm. 2 of those incidents involved being threatened and harassed and intimidated by the local hunting club. It is absolutely out of control. I am tired of it. I'm tired of dealing with it. As a landowner, I feel absolutely helpless on what's going on. There is no law in the book as it exists today to help me with my issues. We are desperate. We are asking for help. And this proposed bill, Senate Bill 99, while it may not be a complete solution for all the problems, it's a step in the right direction. So I support this bill. Fellow landowners support this bill. We're not against dog hunting on places where the people have permission to hunt. But when you have guys, I own both sides of the dirt road where my farm is. And I have had this issue before of guys turning out in the middle of the dirt road to harass me, to intimidate me, because they can. And they'll tell you they can when you have conversations with them. So we appreciate your support. Thank you.
Don't go anywhere.
Yes, sir.
Because I think that Senator Stewart has a question for you.
Okay.
I do.
Right here.
Right here.
Okay.
So your particular problem is people pulling up on the highway and turning dogs loose right onto your property, or is it people hunting another piece of property that extends onto yours?
Both. I have a hunting club that December the 21st, I own 150 acres, okay? There's a 30-acre parcel that adjoins me. I had a hunting club come in there and dump 5 box loads of hounds out on that 30-acre parcel. Hounds do not stay on 30 acres. They'll be in there for 60 seconds and gone. I stopped counting at 21 dogs on my farm in the first hour. What they did is they lined the north side of my property and they lined the west side and they turned them loose on that 30-acre parcel that adjoins me on the east side. So this bill will not solve that problem. But this bill will help me. What I can do is I can put a cellular game camera that will text me pictures. If I'm in Richmond, I'm getting pictures texted to me from Southampton County. If someone's turning dogs loose on the dirt road where I own both sides of the dirt road, at least then I could deal with that problem. But this is not a total solution. There's other states that have come up with total solutions. 4 years ago, I advocated multiple times to DGIF that we propose a permit system similar to Florida, Alabama, and Georgia, and we were advocating for a permit system with no minimum acreage restriction to hold the deer dog hunters. This is primarily an East of Blue Ridge issue. Georgia has a 1,000-acre minimum. Alabama has a 250-acre minimum. I'm open for conversation. There's a problem, and it's a huge problem. So thank you.
Thank you very much. Thank you for being here.
Mr. Chairman, I have a question.
Sir Pete.
Yeah. Sir.
Don't go anywhere.
Yeah, sir. You say they come down your road and intimidate you. Are they threatening you? Are they using guns? Are they displaying their guns in threatening manners, or cussing, or what type of behavior?
Senator Peake, let me say this to you. I've been in the wildlife habitat business for going on 12 years now. And what that entails is I'm a prescribed bird manager in Virginia and North Carolina. Do a lot of early successional habitat work for large landowners in eastern North Carolina, eastern Virginia for quail habitat and upland wildland habitat. And, you know, the amount of attacks I've dealt with personally, my friend here, Mike Hicks, has dealt with from Goochland County. You know, they will hurt. I get text in the middle of the night. I get Facebook messages, you're a dumb SOB because you're against dog hunting. I'm not against dog hunting. I just don't want it on my land. I'm trying to deal with these rogue hunting clubs. So those two incidents you're referencing, it was essentially, they turned the dogs loose on the property line to the north of me, and I called DGIF to CPO, and we had an altercation when they came onto my land to get the dogs. That's what happened.
Did they threaten you or show
Absolutely,
gun?
they threatened me.
Yeah,
Yes, sir. And the Commonwealth Attorney of Southampton County is involved, and I'm pushing to file a protective order against the entire hunting club.
And did they show guns?
They did not show guns. They know better than to deal. They know who I am, and they know I'm a big advocate I'm a property rights guy. I'm an advocate for property rights, and they know that. You know, I've been pretty loud on this issue for 3 or 4 years. It's out of control.
Thank you,
And I
Mr.
killed my first deer in front of a Walker Hound when I was 10 years old, 30 years ago.
Thank you, Mr. Chairman.
All right, thank you very much.
Yes, sir. Thank you.
Yes, sir. Step right up.
How y'all doing? I appreciate you giving me the opportunity to speak today. I'm the same way with Aaron. I've been in this.
Tell me your name.
Oh, I'm sorry. I'm Mike Hicks. I'm a resident of Goochland County.
All right.
My family also owns that land in Essex County. We have basically the same issues in both counties. It's rampant hound trespass. Hunting from the roads is just terrible. It doesn't seem like there's much we can do about it. We had an instance a couple years ago in Essex where dogs got in on the farm that we hunt. The trucks come down the road, lined every 100 yards, and shot from the road. Casings were found in the road, but the game warden did not see it, so there was no prosecution could be made. You know, it's just frustrating that as landowners and ethical hunters that we can't stop this road hunting issue at all. There's like no tools at all to help it. I think this bill would give us at least something to go on, you know, and help a little bit with what's going on here.
All right, thank you very much.
Thank you.
All right, Sir Marsden, you want to wrap? Well, let's see. Anybody want to speak in opposition to the bill?
Good afternoon, Senators. Kirby Birch on behalf of the Virginia Hunting Dog Alliance, and we oppose this bill. Thank you.
Thank you. Anybody else? Anybody have any questions of the patron? Bill is before us.
Can I just wrap up one
Go right
second?
ahead.
Thank you, Mr. Chairman. Property rights are an important thing. Public safety is an important thing, and I know it's important to this committee. I've actually had a conversation with the Attorney General to advise him that things are getting out of control. I've got a phone here filled with photographs, with pictures of dogs running across properties, people who are afraid to let their companion animals out in the yard because the dogs are coming on the property. I'm very concerned about the confrontation that we're setting ourselves against each other, neighbors against each other in this. And this is a small way of moving forward on this, but we're going to have something bad happen here, and I would hate to see this General Assembly, this Attorney General, this Governor sort of caught off guard, and the newspapers and everybody else asking, what have you done to deal with this ever-growing problem? And I think this is a small step. I don't think it's going to interfere with responsible hound hunting. I think it will help protect the rights of property owners who just don't have the ability to enjoy the use of their property as the way they intended. They're woken up in the morning on Saturdays to the sounds of hounds running through their woods and their fields and their yards. And so I'd ask the committee to give this serious consideration, and let's see if this can cut back a little bit on those who are behaving badly, because there's a lot of good hunt clubs out there too who do this the right way. Thank you.
All right, bill's before us.
Mr. Chair.
Well, let's act on it in some
I'll
fashion.
move to report it.
All right, there's been a motion to report. Is there a second? Properly seconded. Clerk will open the roll.
Ayes 4, noes 11.
All right. Senator Marston, thank you very much. And I think that this is an issue you've identified, and it's a creative solution. I commend you on, and I'd be happy to continue to maybe talk with you over the next year and see if we can be a little more creative.
Yeah,
Okay?
thank you,
All right,
Mr.
now
Chairman.
we've got Senate Bill 811.
Yes, sir. We have a substitute?
I hope so. Terrible. Senator Stewart moves, Senator Norman seconds the adoption of substitute. All in favor signify by saying aye. Aye. All opposed, substitutes before us. All right. Sir Marston, why don't you tell us what my understanding is this bill deals with people are subject to a protective order. It requires them to surrender to law enforcement their firearms or certify that they have done so. Surrender to law enforcement or sell to a licensed dealer.
Yes, it expands on that a little bit, Mr. Chairman, and I can explain what the bill does. And as you know, several years ago, there was sort of a compromise done on the concealed carry permits from out of state and the idea of the surrender of firearms in a protective order situation. And one of the problems that we had is that there was no mechanism really in place to do this, no procedural steps that people were given as to how to surrender their guns and instructions to judges as to what their responsibility was. So this bill does three things to further clarify the law regarding protective orders and the requirement that a person subject to a protective order is required to surrender their firearms under the penalty of a Class 6 felony. It says the circuit court shall designate, this is the chief judge of the circuit court, shall designate the law enforcement agency responsible to receive the firearms and requires that the address and hours of operation of the law enforcement agency be supplied to the person subject to a protective order. Secondly, it requires a couple of forms to be created by the Office of the Executive Secretary of the Supreme Court. And these forms to certify that the person subject to the protective order, one form says, I do not possess any, and it certifies that they do not possess firearms and therefore have nothing to surrender. Or if they do possess firearms, an additional form will certify that they have surrendered, sold, or transferred their firearms according to this statute. It just verifies that that's been done. And finally, it allows for the transfer of the weapons to any person who is not otherwise prohibited by law from possessing firearms. So it expands a little bit the number of folks that you can and trust with these firearms during the pendency of this protective order, and allows for these folks to hold the weapons for these individuals. And so that's what the bill does. Provides direction to the circuit court, provides directions to those under a protective order, and it allows for some additional options for transfer.
Senator Norman.
Senator, you indicated that the original bill was the result of a compromise that was brought about some time ago. Are all the parties that were involved in that compromise in concurrence with the substitute that you've offered on 811?
I certainly have spoken to some folks who are, but I think people are here today. They can either agree with the bill or not agree with the bill, but I think it provides us with a better mechanism for instructing everyone involved as to what they need to do. And I do have a witness here from the...
Mr. Chairman, my concern is that anytime we work out these compromises, I'm reticent to disturb them within a short period of time unless there's concurrence by all the parties that previously had agreed to them. And I just offer that as my very myopic perspective.
I understand, Senator Norman, your concern in that area. The problem has been is that In some areas, there's been no enforcement of this. There's been no knowledge of how to proceed. Other places have sort of figured it out, but what this would do is give a consistent policy across the Commonwealth that judges could be instructed in to instruct those subject to a protective order. And I think we'd have a procedure here that will work for everyone. And I did want to call up some.
Dave, let's go ahead and listen to your witnesses who want to speak in favor of this bill.
Well, if I could, Mr. Chairman, I had somebody who.
That's what I'm doing, trying to get your supporters up here. All right.
Good afternoon, Sushila Varkey with Virginia Poverty Law Center. So one of the local legal aid attorneys had a student do a survey of all the jurisdictions in Virginia, of which there are 123. So let me just read you some statements about what is happening in these jurisdictions in response to the question, how does the court notify the respondent about the firearms prohibition in family abuse protective orders, the up to 2-year one? In 36 jurisdictions, the judge gives the respondent a verbal notification when issuing the protective order if the respondent is in court. 12 jurisdictions, the bailiff gives a verbal notification when serving the protective order in court. 16, the court attaches a written notification to the protective order that's served on the respondent. In 18 jurisdictions, there's written information available in the lobby or the clerk's office, but the respondent has to go seek that out. And in 25 jurisdictions, nothing has changed since the passage of the firearms prohibition. So the point is it's very spotty, and as Senator Marsden said, to try to get some uniformity. And it's not changing the law, it's just really implementing what the law was as part of the compromise in 2016.
All right, thank you. Anybody else wish to speak in favor of this bill?
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support this bill because we don't like the idea of a patchwork of enforcement.
Mr. Chairman, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We support this bill. As many of you may know, intimate partner homicide happens at an incredible rate in the Commonwealth, and one of the most at-risk times for women who are trying to escape their abusive partners is when they obtain a PO, a protective order, or when they're pregnant.
Mr. Chairman, members of the committee, Nikki Zamosny, Assistant Secretary of Public Safety and Homeland Security, and the administration supports the bill.
Thank you.
Dana Schreiber with the police chiefs. Not so much a position as a question, because it does impact how law enforcement would feel about this particular legislation. Many of our law enforcement agencies do take these bills into possession.
You're using up the supporters' time. Why don't you let the other supporters step up, and we'll let you speak in ambivalent time, okay? You don't get all 3 minutes.
Good afternoon, Kelly Roscom, Legal Director with the Educational Fund to Stop Gun Violence. We support this bill. I understand that this was the result of a compromise several years ago, but it lacks enforcement mechanisms. This would provide a little more teeth on the end of that. Thank you.
Yeah, thanks. Before we go to opponents or Dana, you know, it occurs to me that from what the Poverty Law Center indicated, you know, maybe you've identified a problem that we need to give better notice to people who are the recipients of protective orders. But what you're doing is not giving better notice, but you're criminalizing, you know, the people for, you know, not doing what the law requires. And you know, I might be able to support a better form, better notice, more uniformity, but this gives me great pause. Let's hear from Dana and then maybe the court.
So just a brief question. The basis for the court order that says that the gun should be surrendered to a law enforcement agency or sold or transferred, what's the mechanism for the court making that decision? What's the rationale? And that would be our question.
All right, thank you. Let's hear from Supreme Court.
Doreen Dalton, Office of the Executive Secretary of the Supreme Court of Virginia. Having just seen the substitute, we're not taking a position, but we're raising the same sort of issue as to the court's designation of which law enforcement agency should be receiving the guns, and it seems as if the chief judge is required to make that designation as to which law enforcement agency. So it's raising the question as to why that would be the case, and if it would be better for law enforcement to actually make that designation.
Okay, thank you. Senator Stewart.
I would like to ask the lady from the Supreme Court, wouldn't this be a good topic for the Committee on District Courts to discuss and maybe figure out a way
We
to...
could certainly review that if that's what this committee would
All right.
wish.
If opposition wants to be heard?
Aaron Looper with the National Rifle Association. We oppose this in first glance with the substitute is there's no process for repossession of the firearm or process for which the condition that the firearm would be kept. The other issue from first glance is 24 hours. Now we were part, as Senator Norman mentioned, we're part of the deal that was worked out, and we were definitely in support of a 24-hour period of no longer being in possession of the firearm. But as far as a surrender provision would go, we would oppose that. So, thank you.
Philip Van Cleve, President of Virginia Citizens Defense League, agree with everything that Aaron just said. On top of that, if police are going to be accepting these guns, and like, a lot of people have a lot of guns. In fact, it could be a gun dealer who could have hundreds of guns. The police have to have somewhere to store that. There's going to be locker costs. Basically, there's going to be a cost to do this, so I'd probably need an appropriations. Thank you.
Thank you.
Mr. Chairman,
Senator Marsden.
If I might, these are matters for localities to determine. When a judge designates a law enforcement agency, he doesn't do that, off the cuff. He's going to call the chief, call the sheriff, and say, which of you guys can do this, and what circumstances can you do it under? This is how local government works. And I didn't want to get a bill here that starts designating as to what, law enforcement that requires law enforcement agencies to absolutely have to do this. It's up to the chief judge of the Supreme Court to work this out in his communities, and he has a number of them.
And Senator Marsden, you mentioned that, and that, I guess that's what's confusing me about this bill. We developed the policy, and we voted on it last year, the global policy. Isn't it up to the Supreme Court to work out the details of how these things are implemented oftentimes?
Well, I would agree, Senator Stewart, in terms of but the agents of the Supreme Court really, statewide are the judges of the courts. And helping them make policy in their communities, it certainly wouldn't be appropriate for the executive secretary's office to make a policy that all of these, that police departments have to do this or sheriff's departments have to do this. It's up to communities to figure out who's got the best resources and what the best way to solve this problem is.
That's not what your bill does. Your bill directs courts to do certain things or people to do certain things with their firearms. My point is, shouldn't it be up to the court system to establish the rules as it does in all other aspects of the court?
I believe you're correct, and this gives the court greater guidance as to how to comply with that.
My point is, I think this is a good topic for the Committee on District Courts to look at and develop a policy that works, and the court knows the intricacies of the court better than we do.
Senator Norman.
Mr. Chairman, I'd make a motion that we pass the bill by indefinitely and send a letter to the the Committee on District Courts to take a look at it.
All right. Motion has been made and seconded. Any discussion? Hearing none.
Mr. Chair.
Senator Peterson.
Yeah, one thing, and this concerns me a little bit, is the statute currently talks about knowingly possess a firearm, but the bill here says possess a firearm. So let's say, for example, you have a farm and you have firearms at the farm, and there could be a distinction between what you have you knowingly possess because it's around you versus what may be within your ownership but may not be immediately at hand. So I think this is slightly different than the statute that we have in front of us right now.
That might have been a scrivener's error. I'm not sure in terms of that, because we did rearrange the language in the bill and move it around a little bit, and that could have happened.
All right. The motion is to pass the bill by indefinitely with a letter going to the Committee on District Courts. Clerk will open the roll.
Hey, green lights.
That's good.
Ayes 15, no 0.
All right, Senator Favola, we've got Senate Bill 802.
Thank you, Mr. Chairman. This is a sentencing bill, and what it says that if an individual who's already convicted demonstrates severe mental illness at the time that the crime was committed, the death penalty should not be applied. So we define severe mental illness in lines 46 through 51, means the exhibition of active psychotic symptoms that substantially impair a person's capacity, to appreciate the nature or consequences of their deed, or to exercise rational judgment, or to conform the conduct to the requirements of the law. And this would be applied. A defendant would be entitled to call an expert witness to do an evaluation to determine if severe mental illness was present at the time the crime was committed. The prosecution could call an expert witness. The findings would be presented to either a judge or a jury. And what this bill says is, if a determination is made by the jury or the judge that there really was severe mental illness at the time of the crime, the death penalty should not be applied. And I bring this before you because the Supreme Court has been ruling recently about culpability. And as you know, in 2002, they ruled that an individual who is, quote, mentally retarded does not have the understanding or culpability to fully comprehend his or her actions and should not be put to death. Prior to that, there was a culpability argument or decision rendered from the Supreme Court on juveniles. So this is sort of this is one category of folks who I think would fit under the Supreme Court, the earlier rulings, but the Supreme Court hasn't identified those with severe mental illness. But I believe
All right.
we should exempt them from the death penalty. It has nothing to do with the verdict. So an individual could be found guilty. This is a sentencing bill. I do have a few speakers.
All right. Be happy to hear from the speakers in support of your bill.
Good afternoon, Mr. Chairman, members of the commission. My name is Rhonda Thyssen. I'm with the National Alliance on Mental Illness of Virginia, also known as NAMI Virginia. And on behalf of our members, I'm here to speak in support of this bill. Senator Favola kindly took most of my talking points. So I'll just say that, just like individuals with intellectual disability and juveniles, folks with severe mental illness may have diminished capacity to communicate clearly, to learn from experience, to engage in logical reasoning, to control their impulses, and to understand the consequences of their actions. And for this reason, we really believe that folks with severe mental illness should be treated the same under the law with respect to application of capital punishment. Thank you.
Thank you.
Hi, Chairman, committee members. My name is Jenny Halborn. I'm with the Disability Law Center of Virginia, and we're in support of the bill.
Thank you.
Mr. Chairman, members of the committee, my name is Kevin Maurer. I'm with the Virginia Catholic Conference. We believe that the state should not be putting to death those who are among the most vulnerable in society, including the mentally ill. Thanks.
Thank you.
Thank you. Bruce Cruiser, Executive Director of Mental Health America of Virginia, the State Mental Health Association, and on behalf of our 8 local affiliates around the state, we also support the bill. Thank you.
Thank you.
Mr. Chairman, members of the committee, Claire Guthrie Gastanaga, on behalf of the 42,000 members of the ACLU in Virginia, we also support this bill.
Thank you. Anybody else wish to speak in support of the piece of legislation? All right, we'll hear from folks who would like to speak in opposition.
Good afternoon, Mr. Chairman. Nancy Park, Commonwealth Attorney for the City of Chesapeake, here on behalf of the Virginia Association of Commonwealth Attorneys, and we do oppose this bill. We have opposed this bill in the past when it has come up. The current state of the law is, of course, in the guilt phase. If they are suffering from a severe mental illness that impacted their ability to commit a crime, there's the not guilty by reason of insanity. And that is already covered. And so if you were that mentally ill and suffering, then in the guilt phase, you're going to be found not guilty by reason of insanity. And so this is, if you don't meet that burden, which is the same burden, the greater weight is the same as preponderance, then they get a second bite at the apple in the sentencing stage, which for all purposes they already have now, because in a capital murder sentencing stage, all of that evidence comes in and the jury considers all of it. There is nothing that says you have to impose a death penalty, ever. And so the jury already considers this information. And I do think that it is very different from the section that addresses the intellectual disability, which is very well defined about how to assess that and what that means and what the jury should look at. So for those reasons, we do oppose this bill.
Mr. Chairman, I have a question.
Yes, Senator Edwards.
Yeah, you're aware, of course, there's a difference between insanity at the time of the offense and a severe mental illness. They're different standards.
Mr. Chair, yes, Senator Titus, but if they're severely mentally ill to the point that they are suffering, that you would think that they would be submitting that also in the guilt phase.
Maybe not.
Maybe not.
Maybe so, maybe not.
All right. Any other questions? Ms. Parr, you can tell the Chesapeake City Police Chief that next time he has any difficulty getting to Richmond, he can just give you a call and get a ride.
Well, Mr. Chair, if I may, when you said that earlier, I was glad because I was in here looking for him. I was like, where is he?
Tell him you'd be happy to bring him the next time he has any difficulty.
Thank you.
All right. Senator Norman.
Mr. Chairman, this is an area of the law that I have a modest amount of knowledge about, and what the senator is proposing is a fairly significant change in the capital punishment statutes as they now exist. And I've always been one that's proceeded with deliberateness when we make even modest changes to our capital punishment statutes. And I'm thinking perhaps the better part of discretion is, rather than this committee acting on it, is to create chagrins on the next to last row back there and have the Crime Commission look at this, sir. So I would make a motion that we pass it by for the year and ask the Crime Commission to examine it.
All right. Motion is pass bill by indefinitely. I understand that the Senator Norman's more familiar than I am with process, but the Crime Commission will undertake consideration of the multitude of requests that it gets sometime at or near the end of session. And Senator Norman, who served as chair of the Crime Commission for many terms, asks that it be considered. I'm sure that it will receive every fair consideration. So motion is pass bill by indefinitely.
Thank
Been
you,
moved and don't go anywhere. May not pass. Moved and seconded. Any further discussion? Clerk will open the roll. Okay. Thank you very much.
Okay.
All right, Senator. Next, we have Senator Deeds, Senate Bill 666.
666. Mr. Chairman, members of the committee, delegate, our Senator Stanley. Senate Bill 666 is one that flows out of the events that occurred in Charlottesville this past August. And it makes impersonating an active duty law enforcement officer the same as impersonating a police officer. You will recall that Tim Hafey, who was the U.S. Attorney for the Western District, was commissioned to do an independent report. And his report pretty much made everybody uncomfortable, and nobody really liked it because it did make people uncomfortable, and it told who did their jobs and who didn't during the the events that occurred on August 12th. One thing that it reports that there were police officers that didn't know who was who. There were people there, if you've seen the pictures, if you've seen any of the film or read anything about the riot that occurred there, or the incident that occurred on August 12th in Charlottesville, there were people with shields and people dressed in military garb and people with lots of weapons, and this doesn't deal with the weapons. This just says if you are dressed in such a way that you impersonate an active duty military officer, you will be punished in the same way that you will be if you impersonate a law enforcement officer.
Let me ask you a couple of questions, and and I understand what you're trying to do, and I don't fundamentally disagree with what you're trying to do. But if we're trying to prosecute somebody who's impersonating a police officer, we do it because they have blue lights and pull somebody over, or they show a fake badge, or they have an insignia on that says police, something like that. Believe it or not, I think in one of the jurisdictions I represent, there's a guy who actually had a fire truck, and he would drive that fire truck to scenes of fires and would impersonate a fireman. I mean, a guy went to a lot of trouble to do it and drove the fire companies crazy, and he was ultimately prosecuted for that. But how do you do this? I mean, would they have to have, Army? I can go buy camo. I can go to a surplus store and maybe even be a vet and wear, my old Army jacket. And I mean, just think back to the Vietnam War protests with all of the vets who showed up wearing their uniforms. I mean, how do you do this?
Mr. Chair, I would point out that the standard right now is one who willfully impersonates with the intent to make others believe. And you've got the same argument could apply to emergency medical services provider, firefighter, special forest warden, fire marshal, or fire chief. That's already part of the law. And this just adds to that. Members of the United States Armed Forces Reserve, or National Guard. And the reality is that morning, it was difficult for people, for civilians to know who the good guys and who the bad guys were. But the Haefy reports, and I didn't point this out yesterday in county, city, or in local government, the Haefy report says that police he interviewed said they couldn't tell. There were National Guardsmen there that morning. He could not, the policemen that were interviewed could not tell who were real National Guardsmen and who weren't.
And part of that, I think, arises from, one of the other things that the Haefy report pointed out is that there were so many agencies involved.
Right.
And the lack of coordination, and you've got law enforcement officers from one jurisdiction looking at people and going, I don't recognize the uniform. There are a lot of issues,
Agree. I mean, there were things in that report that would cause all of us to wonder about what about our roles. But the reality is that young woman lost her life on the streets of Charlottesville, and two police officers who just went to work that morning to do their job lost their lives while they were trying to enforce public safety.
Well, anybody have any questions of the patron? Any other questions?
Mr. Chair.
Senator Peters.
Has anyone ever been arrested on Halloween under this statute?
I don't.
That's a serious question.
Well, and I don't know that, but I know that several years ago, we passed another statute that makes it illegal for an adult to wear a mask.
Well, that dates back to the 1870s.
I don't know whether there's been prosecution under that statute or whether anyone's been prosecuted on Halloween. But again, under this section, there's got to be you're willfully trying to create the impression or impersonation that there's got to be an intent requirement. And I don't think a kid dressed up as a military officer on Halloween's got that intent.
All right, Senator Stewart.
Senator Deeds, do we know, I saw some of the pictures, I don't know if it was in this committee or another, and those were the first I'd seen of those folks who were in military-style clothing. Do we know that they were trying to impersonate guardsmen or somebody?
I don't know that, no. I don't know that.
Anybody have any other questions? All right, you want to ask a question? Or not? All right, the bill is before us.
Second.
Been moved and seconded to report and re-refer to the Committee on Finance. Is that all right?
Okay.
It's got a
That's your
budget
motion?
amendment, yeah.
All right. It's been moved and seconded to report and re-refer to the Committee on Finance. Clerk will open the roll.
Ayes 14, noes 1.
All right. All right, we've got 155. Let's see. Got 155, Senator Edwards.
Mr. Chairman, members of the committee, Senate Bill 155 grows out of an event that actually occurred.
And, John, if you don't mind, 1 second. Just for point of reference, this bill was introduced last year by you, is that right?
That's correct.
Senate Bill 1112 passed by indefinitely on a 9-6 vote. John, go ahead.
And what it does is say that if somebody goes to a city council, well, what it does, it's enabling legislation that authorizes the locality to adopt an ordinance, by ordinance, that prohibits firearms, ammunition, et cetera, at a regular or special meeting of such local governing body, provided one, there's a notice of a prohibition that is publicly posted, and the meeting room is owned or operated by the locality. That is, we had an event in Roanoke City Council where somebody came and sat on the front row and pulled out his gun and just left it there on his lap, as I understand it, at a meeting where there were some young people who were being honored, Boy Scouts or somebody, Cub Scouts or somebody like that. And a number of the council members I've talked to felt uneasy, to say the least, that this guy was sitting there pulling out a gun and put it on his lap. It wasn't brandishing it, but it was just sitting there, just to prove to the world I can do this, I guess. And so because of that event, they said, we would like to at least not prohibit guns in the public buildings themselves, but rather ordinarily, but rather when they're having a meeting in the room by notice and have an ordinance to pass it, passing, say they could, when they have a meeting, put up a notice, you can't have a gun in the room while we're having the meeting, official government meeting. Now, the analogy is the courthouses. You cannot go in a courthouse, without going through a airport style, screening device. And that's because judges will not allow guns in the courtrooms. So it's analogous to that. And I have a representative from Roanoke City who would like to explain it further.
Mr. Chairman, members of the committee, Rob Catron.
Nice of you to come down from Roanoke City.
Yes, sir. As the senator said, Roanoke City Council supports this measure for the reasons he stated. In December and November of 2015, while there was a discussion of whether to put any kind of gun control legislation into the legislative agenda, certain folks decided to come to the Roanoke City Council meeting with firearms. And as the senator said, on that same day, there was a number of young people there being honored for writing essays or their poetry or things like that. And council feels like they ought to have the ability to have a place when they're deliberating without firearms inside with public notice. Again, this is local option, so they support the bill, and I'm here today to let you know that.
All right.
Thank you.
Thank you very much. Anybody else wish to speak in favor of the bill? Anybody wish to speak? Yes, sir. Sorry.
Josh Horowitz, Educational Fund to Stop Gun Violence. We support the bill.
All right, thank you. Anybody else wish to speak in favor of the bill? Anybody wish, you can stand up. Anybody want to speak in opposition to the bill?
Aaron Looper, National Rifle Association, we oppose the bill.
Thank you.
Philip Van Cleve, the Virginia Citizens Defense League, our preemption laws work beautifully. Let's not tamper with them. Thank you.
All right, yes, sir. Thank you.
Mr. Chairman, ladies and gentlemen, Bob Sadler, South Richmond. I cannot begin to tell you how little I relish the thought of leaving my firearm unattended on those streets just to attend a city council meeting. Thank you.
Thank you very much. Any other questions of patron? Bills before us.
I'll vote to report.
Second. All right, it's been moved and seconded. The bill be reported. Clerk will open the roll.
Ayes 6, noes 9.
All right. Next, we'll do Senator Howell, 442.
Thank you, Mr. Chairman. This is Senate Bill 442. This deals with our access to firearms by children law, which we passed way back in 1992. And under that bill, currently, it is a Class 3 misdemeanor to recklessly leave a firearm that could be handled then by a youth under 14. This bill is going to be addressing 3 of those aspects. And I must tell you, the main concern for this is teenage suicide. That's kind of the genesis of this. Currently, it's just a Class 3 misdemeanor that can be up to $500. We would make this a felony. In addition, we would raise the age to 18 from 14. And let's see, and we would remove the reckless standard because other states aren't using that standard. Most states now do have similar legislation. We're, perhaps because we were one of the first states to do it, do have younger ages than most, lower penalty than most. And so this is just trying to bring it up to the current reality of teenage suicide. Let's see. Trying to find the numbers on the suicide. These laws are associated with a 64% decrease in self-inflicted gun injuries among youth and an 8.3% reduction in suicide rates in youth 14 to 17.
Okay. Anybody have any questions of the patron? All right. Those who wish to speak in favor of the bill?
Mr. Chairman, members of the committee, Nikki Zamosny, I'm the Assistant Secretary of Public Safety and Homeland Security. We want to thank Senator Howell for carrying this bill on behalf of the administration. One of the things that we wanted to make note to you is that according to the Academy, the American Academy on Pediatrics, between 2002 and 2014, on an average, 1,300 kids were killed every year with firearms. So we think this is an important piece of legislation, and we thank the senator for introducing it.
Let me ask you, since you mentioned the American Academy of Pediatrics, are you familiar with their firearm safety policy statement?
I am not, Senator.
It actually basically, well, it states that that the absence of guns, the total absence of guns from children's homes and communities is the most reliable and effective measure to prevent firearm-related injuries in children and adolescents. And I mean, since you quote the American Association of Pediatrics, I wonder whether, on behalf of, and I know Secretary Moran's not here, but whether you all would take the position that the removal of the word recklessly would essentially give public safety officials the ability to cite the American Association of Pediatrics in arguing that any person who leaves a loaded, unsecured firearm anywhere in a house is guilty of violating this.
Senator, we think it's important to make sure that loaded firearms are not being left around children, and so we would recommend striking that language.
Okay, so you want strict liability that if there is a loaded, unsecured firearm anywhere in a house with an 18-year-old or under, that they should be guilty of this crime. That's the administration's position.
That is the position.
Okay, I understand.
Even if they can't get to it? Mr. Chairman?
I understand.
It's if it's
Even if they
unsecured,
can't-
if
even
it's
if
loaded or unsecured.
Even if the child can't get to it?
No.
If it was secured, then the child would not be able to get to it.
It's to endanger the life or limb.
Yes.
All right, let's hear from others. And thank you, I appreciate your candor.
Josh Horowitz, Educational Fund to Stop Gun Violence. Thank you, Mr. Chairman and members of the committee. I want to make the point that suicide is up in the Commonwealth 21% in the last 10 years. One of the most emergent areas of suicide, people often in their late teen years, it's very important to protect them from easy access to firearms. And also people make very impulsive decisions. We understand that oftentimes the decision to use a firearm in suicide is done within an hour. And so making sure that unsecured firearms are not available to teenagers thinking about suicide is a very important part of suicide prevention.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety, and a member of the Virginia Violent Death Reporting Systems Advisory Board. I've seen the data on the teenage suicides, especially amongst males, and there's a spike now in teenage suicides in the under 21, but that includes the area 18 and below. And there's also an increase in above 50 for males. And it's a serious thing. We need to keep these kids away from the guns. Thanks.
Thank you. All right, those who wish to speak in opposition.
This is Philip Van Cleve, President of VCDL. Three things on this bill. Number one, there are people under 18 that are perfectly fine to be around firearms. Their parents have trained them, and many lives have been saved because somebody under 18 has had access to a firearm during a home invasion. Number two, this takes away from the parents their ability to decide if their children are mature enough. But it's so broad, and we're talking a felony here. This bill isn't fooling around. It's going to make a felon out of somebody. If a 17-year-old breaks into your home, technically, and you've got a gun that you left unsecured, you weren't expecting the 17-year-old to burglarize your home, you could now be charged with a felony. Also, if your wife happened to bring home a neighbor's kid you weren't expecting to come in the house, you have an unsecured gun, you could be charged with a felony. So we oppose.
Aaron Looper, the National Rifle Association, also is kind of citing the reasons that Phil said for opposing, but also we think current law is sufficient. There is no one-size-fits-all model for securing firearms in your home, as well as we believe it's the gun owner's responsibility to safely and secure and store their firearms.
All right, thank you.
Bob Sadler, South Richmond. In addition to being a lobbyist for VCDL, I'm also a life member of the National Rifle Association. And one of the benefits of that is a monthly magazine. That monthly magazine contains a monthly column called The Armed Citizen. And virtually every single month, there is at least one instance of a minor having to defend themselves from a home invader. It would be a shame to leave them unprotected. Thank you.
All right. Thank you. Senator Stewart.
Mr. Chairman, what concerns me about this, I was in the Marine Corps and I fired all these weapons and I don't do it anymore, but I hunt and I love to hunt. And I've taught my children to hunt. And at 17, my son was more responsible with a gun than probably more 35-year-olds. And if he and I went dove hunting and walked in the house and I put my gun in the corner of the house and didn't realize, or even if I did realize that there was a shell left in the magazine but not in the chamber, and went in to get something to eat, and there was a 17-year-old who was perfectly responsible with a gun, I'm guilty of a felony. And I've worked pretty hard all my life, and I've been a law-abiding citizen, and I've never broken the law that I'm aware of or intentionally. But all of a sudden, I'm a pretty significant criminal. That concerns me. And
But you have-
realize that's what this bill would do?
Yes, and you realize you would have left a loaded firearm unsecured around children.
A 17-year-old who was as capable as any 50-year-old at firing it and understands
But-
that you treat it as it's loaded and you're careful with it and all those things that you teach people who are responsible gun owners.
And he, Mr. Chairman, and your son or the friend who was in the kitchen may be suicidal.
Mr. Chairman, I understand and I appreciate what Senator Howe's trying to do, but this goes too far for me. I'm going to move to pass this bill by indefinitely.
It's been moved and seconded to pass the bill by indefinitely.
Substitute motion?
Can I ask a question?
Let's ask the question first, and then you can make your substitute motion.
I'd ask Senator Howe, is it your intent in the first line to prevent anybody under the age of 18 from picking up a loaded gun or going hunting?
No.
If you live on a farm.
There are other parts of the state that
That's not what they're talking about.
Well, yeah, and that I guess that's what I'm trying to figure out, because I agree with your purpose, but I'm trying to figure out how it would be lawful for any person under the age of 18 to have a loaded, secured firearm that they perhaps got from their parents without exposing their parent to some criminal liability. Say if a parent, if I had a child under the age of 18 and I gave that child a 22 to go rabbit hunting, and that 22 was loaded, well, a loaded 22 is obviously a firearm has some inherent danger. By giving that child the firearm to go hunting, under this language, am I exposing myself to criminal liability?
Absolutely.
To felony liability?
Yeah.
Mr. Chairman, if I might attempt to answer, we do believe the language in line 14 in a manner as to endanger the life or limb of any child, of any person. It was the intention of that language, I believe, which is current law, to apply to the situation you described.
Well,
There has to be some
But isn't that what
behavior.
recklessly did?
Well, we wouldn't, if we want to reinsert the word reckless so we can avoid the strict liability questioning with respect to the chair has identified, and certainly in Senator Deeds' question,
I'm
may
not
very
sure.
well address
Well,
that.
That's not what your Homeland Security Deputy Secretary was advocating, or the American Association of Pediatrics advocates.
I think it was important to have that conversation, recognizing this committee is not willing to adopt strict liability in the situation. I think
Mr. Chair, if the motion for a PBI is withdrawn, I'd make a substitute motion that we strike the word recklessly, or strike the
reinsert.
Reinsert recklessly.
I'll second that.
But we have to. The motion.
There is a motion to pass the bill by indefinitely. That was seconded.
I understand. Mr. Chair, I did say that it had to be withdrawn.
All right, Senator Lucas.
Yes,
All right, there's
Mr. Chairman.
the substitute motion is that the bill be passed.
Mr. Chairman, I believe it has to go to finance. I hate to say that.
And re-referred to the Committee on Finance. The motion is to adopt the bill and re-refer to the Committee on Finance. Open the roll. All right.
Ayes 4, noes 11.
All right. Next, we've got Senate bill. Bill fails to report.
Yeah.
Sorry. Yeah, the primary motion was to pass the bill by indefinitely. Clerk will open the roll.
Ayes 9, noes
So you
6.
can have it both ways. 797.
Thank you, Mr. Chairman.
All right, this bill is identical to a substitute version of Senate Bill 1039 from last session. It did report out of the Committee on Courts 8-6, but was referred to the Committee on Finance, where it was passed by indefinitely.
Yeah, Woodrum.
Right.
When we passed the bill, I guess it was 2 years ago, dealing with permanent protective orders and people under permanent protective orders not being able to possess firearms, it was only in the case of protective orders for family abuse. This bill says it would also cover permanent protective orders for health and safety. The reason I feel quite passionately about this is I think that some of the people most endangered are those who are being stalked. And this would pick up that classification of protective orders.
All right.
And it also needs to go to finance.
Senator Norman.
I'd move to report Senate Bill 797 and re-refer it to the Committee on Finance.
It's been moved and seconded the bill be reported and re-referred to Committee on Finance. Any further discussion? Anybody wish to be, do you mind? Anybody wish to be heard in support of or in opposition? If you want to register your support, all right. Register your opposition. Anybody opposed to this? Okay, thank you. All right, the motion is to report and re-refer to the Committee on Finance.
Ayes 12, noes 3.
All right.
Thank you.
Thank you. Next, we've got Senator Lucas. Senate Bill 59.
Thank you, Mr. Chairman. I have three measures before you this afternoon, and you want me to start with
Well, let's
SB?
start with Senate Bill 59. This was actually passed out of courts last year on a 9-6 vote.
Yes.
And passed the Senate and languished in the House of Delegates
Yes,
last
sir, it did.
year.
And
All
I'm
right.
just hopeful that maybe I'll have better luck on the other side this year. So
All
I will
right.
not go through all of the information that I presented to you last year.
Well, this is a DCJS training standards
That is
bill,
correct,
right?
sir. Yes, sir.
Okay. Why don't you just give a brief
Okay.
description of the bill?
All right, as I indicated, you saw this bill last year, and it required the Department of Criminal Justice Services to develop and deliver training curricula on fair and impartial policing, impartial bias, and verbal de-escalation courses, which will be mandatory for all law enforcement officers to meet basic and in-service training requirements. The bill also directs DCJS to provide technical assistance to law enforcement agencies in implementing modern community policing philosophies. This bill will also require that state agencies with law enforcement officers such as state police and ABC to have their officers take this training either in a basic training, new officer, or at an in-service class for existing officers.
All
So
right.
with that,
And as I recall, last year, there was some discussion about whether DCJS already provides this de-escalation training.
That was the question, and I'd like to
Right.
refer to someone from Secretary Moran's office to respond, if you know. I'm sorry, DCJS. Sorry. I call on Brian for everything. Sorry.
Good afternoon, Mr. Chairman. My name is Tom Fitzpatrick. I'm at the Department of Criminal Justice Services.
Thank you, Tom.
No problem. So we are currently in the middle of a job analysis. Last year's budget bill required the agency to look comprehensively at all of our training standards that are going on, and we're in the first of a 2-year study on that. So with regards to the question on what are we currently doing, we are evaluating all of our training standards.
Okay. So
there are
so it may be unnecessary to do this. Is this an administration bill?
Yes, sir, it is.
And the administration has some say in
Well,
what
let's say it
happens
was
in the
last
Department of
year. It was last year. Yes, sir. It was last year.
Yes.
Is it this year?
Well, because of their study, Mr. Chairman, we hesitated putting it in again this year until the study was completed. But we very much in favor of that training, very much in favor of that. But frankly, we were waiting for them to complete their evaluation.
We have a very powerful executive branch, and I think many of us have great confidence in your ability to direct the direction of this study by the Department of Criminal Justice Services.
Well, I have no problem holding this bill until after the study is done.
Okay. All right. So, sir, you want to move to carry the bill by for the year?
Yes, sir.
All right. It's been moved, and is there a second? Second. All right. All in favor of carrying the bill over for the year? All right.
Ayes 15, no zero.
All right. Senator Lucas, you've got Senate Bill 79.
Yes, sir. Again, Mr. Chairman, members of the committee, you saw this bill last year. The legislation addresses a gap in the law. Elementary, middle, and high schools are covered, but not preschools. Absent language in the Code of Virginia, a policy prohibits representing preschool would not stand against legal challenges, thereby making such a policy unenforceable. This code change will protect some of our most vulnerable citizens and the individuals that care for them on a daily basis. And my speaker, who was here from Alawite County, had to leave because of the weather. So I'm sorry, I may not have anybody to speak to the bill this year. I put it in for them.
Mr. Chairman,
Sarah Edwards.
question is all you're doing is adding preschool to
That's it.
what's already prohibited with elementary schools,
That
middle
is
schools,
correct.
high schools, et cetera.
All right. And I'd point out this was heard last year, and it did report out 7-6 and went to finance. All right. Anybody wish to speak in favor of this bill?
So I'm trying to cut it short.
Virginia Assembly of Independent Baptists would like to support this bill.
All right. Anybody else?
Oh, I think
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. We believe children under school age or preschoolers should have the same protections as children slightly older.
Well, thank you. Excuse me.
Mr. Chairman, Virginia Catholic Conference also supports this bill.
Thank you.
Mr. Chairman, the Educational Fund to Stop Gun Violence supports the bill.
Okay. All right. Those in opposition?
Philip Van Cleve, VCDL. There are no problems with this currently, and I tell you what, a lot of churches have daycare or preschool in them. Where is the line drawn? Where can you carry in the, on their property? So, but again, there's really not a problem with this. We shouldn't keep restricting things. It's only going to put people in position of getting felonies that shouldn't be getting them.
Come on up. You can come up.
Okay.
Louise.
Karen Luke with the National Rifle Association, we oppose the bill.
All right, thank you. All right, anybody have any other questions of patron? Bills before us. Senator Norman.
Mr. Chairman, I'd move to report the bill and re-refer it to Committee on Finance.
All right, it's been moved and seconded the bill be reported and re-referred to the Committee on Finance. Clerk will open the roll.
Ayes 9, no 6.
All right. And you've got Senate Bill 385.
Yes, sir, and I have no illusions whatsoever. This bill reinstates Virginia's.
You're a Presbyterian too.
This bill reinstates Virginia's previous one handgun a month policy and prohibits individuals from purchasing more than one handgun within a 30-day period. Gun violence prevention advocates support this legislation as it will enhance public safety and prevent gun violence. Until 2012, it was unlawful in Virginia to purchase more than one handgun per month. For 19 years, while this law was in place, public safety was enhanced not only in the Commonwealth of Virginia, but in neighboring states as well. Similar legislation has been entered each year and has been unsuccessful. Virginia has been identified as a major source state for firearms that are recovered in other states, and currently there are no limitations on the number of handguns that can be purchased each month, which creates an avenue for gun trafficking to stockpile weapons. This legislation would help to curtail handgun trafficking and stockpiling by reinstating the one handgun a month law.
All right. Anybody have any questions of Patron? Anybody wish to speak in favor of this?
Mr. Chairman, members of the committee, Josh Horowitz, Educational Fund to Stop Gun Violence. Virginia is one of the top exporters of crime guns to other states, where it's the #1 source of crime guns in New York, West Virginia, Maryland, D.C., but also, because of our easy access to firearms, allows too many firearms to be trafficked to our own citizens and used in crime in the Commonwealth. 5,000 guns recovered in the Commonwealth this year were purchased here. We need to do something not only to stop the export, but we need to make sure that we're doing something to stop the easy proliferation of firearms into our own communities. Thank you.
Thank you very much.
Andrew Goddard, Virginia Center for Public Safety. I echo what Mr. Horowitz just said, but I would also note that we are one of the lowest states for importing crime guns, which is an indication of the fact that we're supplying our own criminals at a rate that they don't need to go anywhere else to get their guns. Thank you.
Thank you very much. Any other speakers in favor?
Mr. Chairman, Brian Moran, Secretary of Public Safety. We strongly support the bill. Many of you are familiar with the law when it went into effect in 1993 and then repealed in 2013. Would ask you to reinstate the law. I think it was helpful at that time. It would be helpful again to prevent the exportation of firearms, as was previously mentioned. Thank you.
Thank you very much. All right. Anybody wish to speak in opposition?
Aaron Luke with the National Rifle Association. We oppose this bill. It sets an arbitrary limit on the frequency that a law-abiding citizen can exercise a constitutionally protected right. It does nothing to prevent criminals from using illegal means to acquire illegal firearms, and it does nothing to reduce crime, but just sets more restrictions on law-abiding. Thank you.
Sneaking up on you there.
That's okay.
Philip Van Cleve, VCDL. Yeah, we oppose the bill. We've tried this. New York wasn't happy with us before we passed this law. They weren't happy with us after we did it. It really didn't make a difference. And so we oppose. Thank you.
Mm-hmm.
Ladies and gentlemen, Bob Sattler, South Richmond. Let me explain to you exactly what this bill will do and won't do. What it will do is delay gun traffickers by about 2 hours. It's this easy. You go to this gun shop, 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 meet me back here in 2 hours, and I'm driving up 95 with a trunk full of guns, even if I haven't bought my one gun a month. Now, what this bill will in fact do, and I speak not as a policy analyst, but as a witness, this happened to me. I went to a gun show, found an automatic that I liked, price was competitive, so I put my paperwork in on it. This is back when we had that mess with the Firearms Transaction Center, so I went and did a little shopping. Next aisle over, I found a beautiful revolver, mint condition, dream gun, great price. So I ran back to cancel the first transaction. The guy looked through his clipboards. He said, "Yeah, you're all ready to go." So I had to run back, talk to the state police, see if I could cancel the transaction. They weren't in the mood to be helpful, so I wound up going back and settling for the lesser gun. As I was filling out the last of the paperwork, the dealer said, "You have your handgun permit." I said, "I haven't gotten to the courthouse yet." He said, "If you had your permit, you'd be exempt from one a month." Ruined my day. So
I think we
Whether
got
I'm
it.
exempt or not, this is lousy law. It
Thank you.
doesn't stop traffickers.
Thanks, Bob. All right, bills before us.
Mr. Chairman, you know we only talking about handguns, not rifles.
I know,
Okay.
I know.
Move the report.
All right, there's motion made and seconded to report this bill. Clerk will open the roll.
No surprises here. Thank you.
Ayes 4, noes 11.
Thank you very much. And we are kind of near the end, and it looks like we've got 1, 2, 3, 4, 5 bills left. Senator, maybe fewer. Senator Reeves, why don't you go? 479. Okay. Okay.
Thank you, Mr. Chairman. Senate Bill 479 is a bill that would raise the threshold if you wound up killing or injuring of a police animal in violation of 18.2.144. So it's a one-line addition. This bill came at the request of my Commonwealth attorneys who's here today to speak about that, Travis Smith. I have some interesting facts that I didn't know about. And the average cost it takes to actually train a police dog and the amount of monies that go into that, as well as if you're looking at a dollar figure. And we often talk about crimes as far as a larceny and those sort of things being a felony. So, but I can go into that if the committee has questions. If not, I'd like
Bryce, I
my
think,
witness.
yeah, I don't think anybody has questions. I may be wrong, but we'd be happy to hear from your Commonwealth's attorney. And Bill will have to go to Committee on Finance after, if we act favorably. Yes, sir.
Yes, Chair and Committee, thank you. Travis Bird, Commonwealth Attorney, Spotsylvania County.
Good to see you, Travis.
Thank you, I appreciate it. I will tell the committee members that the Virginia Association of Commonwealth Attorneys, the Virginia Association of Chiefs of Police, and Virginia Sheriff's Association all support this bill. What this does is simply recognizes what the law already does, that law enforcement officers and law enforcement animals, attacks on them are attack on the foundations of law and justice in our society. These dogs not only make arrests for us, and sometimes they protect suspects because they're a less than lethal option, but they detect bombs, find missing persons, find deceased bodies. They take a large amount of drugs and guns off the street. They recover stolen property, and of course, in the worst situations, they take bullets for our officers and for our citizens. And lastly, at the end of the day, there is a large financial cost to localities and jurisdictions when these animals are hurt. The startup first year cost for a canine is roughly between $35,000 to $40,000 for a locality to train and get a dog up and running. So there is a financial impact to the localities as well. But at the end of the day, it's just also a public policy position that we have enhanced punishments for firearm use in this Commonwealth and certain crimes, and most certainly our four-legged police officer should also be protected by the 3-year mandatory use of a firearm during commission of crimes against them. I ask that you support the bill.
Mr. Chairman, I'd make the motion unless anybody else wishes to speak.
Anybody wish to speak in opposition or register their opposition to this bill? All right, your motion is to report and re-refer to the Committee on Finance?
Yes, Mr. Chairman.
Is there a second? Second. All right, it's been moved and seconded. Clerk will open the roll. All right, and I apologize. I have been waiting for Senator Carrico to come. And I think that there are a few people in the back of the room who've been waiting for Senator Carrico to come into the room as well. Senator Carrico isn't coming into the room. We are going to ask, if you don't mind, unless there's an objection, Senator Carrico has asked for, I think, Mr. Van Cleve to step up and briefly be an advocate for his, Senator Carrico's bill, Senate Bill 493. So 493, if you'll hold on 1 second, let me just introduce the bill. Senate Bill 493, this can't be it. That is. is a bill dealing with the possession of concealed handguns at institutions of higher education. This is similar to Senate Bill 1450 from last session. That bill was passed by indefinitely in this committee on an 11-4 vote. Phil, you want to register your support and simply state why?
Okay. Philip Van Cleve, VCDL. This bill allows anybody with a concealed handgun permit to be able to carry on public higher education property. That's somebody 21 or older with the training and so forth, only permit holders. And this has worked not only here in Virginia. Liberty University's now had, I think it's like their 3rd year or 4th year doing this. Works perfectly. No, real quiet over at Liberty. A bad choice of someplace to attack. And it's worked. They've got laws like this in Texas. They've got laws. Utah has had this for a decade. And I haven't heard of any school shootings in Utah. And so it works where it's had. Again, the people that get these permits, this is not saying every college student has to carry a gun. These are people that are getting permits, that care enough to get a permit, that have gone through all the steps to do it. These are not the kind of people that commit crimes. It's just simply not. These are perfectly trusted people. They carry everywhere else they go. A school is nothing but a bunch of buildings. So we like this bill. I would hope that you could support it. Thank you very much.
All right, thank you for standing in and being an advocate. Anybody want to speak in support of this bill? Hold on. Don't jump up too fast. All right, now you can jump up, unless you want to preempt. Senator Norman.
In an effort to expedite it, as someone who spends a lot of time on campus teaching, and having graduated with my undergraduate degree from a school that had more firearms on it than any other campus in the Commonwealth of Virginia, I respectfully ask that we pass Senate Bill 493 by indefinitely.
All right, there's a motion properly seconded to pass the bill by indefinitely. Clerk will open the roll. Somebody have Sassloss?
Ayes 9, noes 5.
All right, bill is passed by indefinitely. Oh, I'm sorry. Oh, okay. All right. There's a motion to reconsider the vote by which Senate Bill 493 was passed by indefinitely. All in favor signify by saying aye. Aye. All opposed. Motion is back before us on the motion to pass the bill by indefinitely. Clerk will open the roll.
And this is just the motion to reconsider?
No, this is the PBI. Janet, she's not here.
Ayes 8, noes 6.
All right, the bill is still passed by indefinitely. Senator Peake, Senate Bill 334.
Mr. Chairman, remaining members of the committee, I'm happy to pass these all in a block if it's the will of the committee. No, all right, 493.
334.
334. Yes, this is
Expungement.
of the drinking. Yes.
You're under 21.
Under 21 drinking. This is different than, I do not include marijuana in my bill, so it's different than Senator McDougal and whoever, other senator. They had marijuana in theirs. I do not have marijuana in mine. Mine only includes alcohol. And the reason for mine being different, I voted in favor of Senator McDougal's. Marijuana, they may commit again.
All right, so basically, if we liked Ryan's, we'll love yours.
You'll love mine even more.
I got it.
And alcohol,
A little slow on the
once they
uptake.
turn 21, they'll never commit this offense again.
All right. So, the bill
They
is
can't be
before us.
underage again.
Anybody have any questions of the patron?
Move to report.
All right. Anybody in opposition to the bill here? All right, motion's been made, properly seconded, to report and re-refer to the Committee on Finance. I'm sorry?
One of the
Oh,
Commonwealth's.
I'm sorry. Come on. You don't like it for the same reasons that were articulated with respect to the broader bill.
That's correct, Mr. Chair.
All right. The motion is to report and re-refer to Finance. Clerk will open the roll. All right.
That's 14, no zero.
Congratulations.
Yes, sir.
338.
338. This is a bill that I have brought, and it applies to courthouses. There was some confusion early on that this was going to apply to courthouses during court proceedings. This only applies to after hours when there may be a board of supervisors or some non-judicial use of the courthouse. And I have two people here to speak. Or I have several people here to speak in favor of the bill.
Okay.
If I have any questions for you.
Yeah. Let me ask
Chairman.
let's
Yes,
ask
Mr.
a
Chairman.
couple of questions first before we get the witnesses
Yes.
up. And it may be that some of the folks are going to address this. Number one, can the judges already enter an order saying, no use of the courthouse for non-judicial purposes?
I do not know, Mr.
I
Chairman.
think they can, and I believe that I live in a jurisdiction in which they did that, and it's too bad, but they do sometimes. Second is, as is evidenced by my votes. I mean, I'm as pro Second Amendment and want to protect law-abiding citizens' right to keep and bear arms, but I'm curious is how do you address the concern that some might have about, I guess, stashing? So
Yes.
you're using a courthouse, and tomorrow is a capital murder trial, and you have a civic group meeting the night before without deputies, without people, and I mean, heck, it used to be with our jurisdiction, the clerk would give me the key to the courthouse, and I'd lock it up, unlock it, and lock it up. I couldn't get into the clerk's office, but I actually used to lock the door when our meetings were over. I swear. And
Is
how
that
do
clerk still
how do you
serving?
address the
Mr. Chairman.
the stashing issue?
I understand that concern. I've heard from the Sheriff's Association with that concern, and I believe the state police to a certain extent, but no, sheriffs. I understand the concern. I've spoken, if somebody's determined to commit a bad act, they're going to find a way to commit a bad act, either shoot their way in or whatever. Stashing, but I know the sheriff's concerned that they'll have to perform sweeps the next day. I've heard that concern.
Okay. All right. Anybody else have questions of patron? Senator Stewart.
Senator Peake, just along the same lines, is there a separation of powers issue here? It was my understanding that the circuit court judge controls that courtroom, sets the parameters for its use, be it during court or after hours or whatever. And so are we invading their province when we try to establish a policy like that when they're in charge of the courtroom?
Mr. Chairman, Senator Stewart, I have not researched that, but I certainly hope not, although they may be able to enter some orders. It is county property administered by the county. I do not know, but I hope that is not the case, that that a judge would have complete and total control over a municipal building or a county building.
Mr. Chairman?
You finished. Senator McDougal.
I can understand the issue if you have a standalone courthouse, like some of our old courthouses used to be. But most of the courthouses I go into are not standalone. There's lots of other offices in there. There's Commonwealth Attorney's Office, there's law libraries in there, and in some, like here in the city, there's other offices that are in that same building. So I don't see how you can isolate it to be the courthouse used in other types of operations because it's got other types of things going on. So I am sympathetic for the situations if there's a public meeting or some other group meeting, but I do have some real concerns about having a courthouse where the Commonwealth's Attorney's Office is and other things that oftentimes are open when courthouse is not being open. And then sometimes the supervisors are even meeting in those offices. And what if those are going on at the same time? So you have another meeting and you have a jury trial that goes late. So which rule do you fall under?
I would submit that, Mr. Chairman, Senator McDougal, that what you've just said is a reason why we should pass this bill, because you do have other offices, and so you're right. You have your courthouse, which is connected oftentimes to other municipal offices. But why should you be prevented to taking your gun, firearm, to the treasurer's office, to the county commissioner's office, to other offices in there? So I submit that it goes the other way, Senator McDougal.
All right. Let's hear from people in support of this bill.
Philip Van Cleve, VCDL. Reference Senator McDougal's comment. Currently, the Supreme Court's already ruled that there are rooms in a courthouse that are not part of the judicial system. They're not considered part of the courthouse anyhow, but we do have a problem with how do you access them then. Also, as far as Senator Stewart's comment, you're already telling courts what they can do as far as firearms. You got the law. So if you're talking about separation of powers, the states are already in a position of the General Assembly putting a law there that says you can't have guns in there. I'm just saying we are doing that to some degree, so I suppose it's acceptable to control it somewhat. But I have been to a courthouse where after hours, they had a Board of Supervisors meeting. There was a sheriff's office there, but they didn't have the metal detectors on. Anybody could go to and from that meeting in the courthouse, and they didn't have a problem with that. Then there was a case in Northern Virginia where I guess City Council owned the room. They let the court use it for traffic stuff during the day. They had metal detectors up, and as soon as the night came, they put them down. They let people carry in there. So I think this is a good bill. Lets people attend public meetings if they hold them in a courthouse, and they don't have to. If the court judge doesn't like that, no meetings in my courthouse. That's fine.
Thank you. Yes, sir.
Ladies and gentlemen, Bob Sadler, South Richmond. One of my first forays with Philip was to a county meeting in Sussex. And I don't know if you've been to Sussex, but the building is not particularly well labeled. If you pull up at night, you don't know what you're looking at. And we were just coming up on the front door, and I guess luckily my jacket must have flapped open. And this very helpful deputy said, hey, you can't go in there. I said, isn't this the government building? He said, no, yeah, it's the government building. It's also the courthouse. So if not for this fellow, I could have walked right through the magnetometer and committed a crime and gotten locked up. Another good example, I believe it's out in Isle of Wight. There's a building that is the oldest existing courthouse in the country. But it's only used as a courthouse one day a year. Every other day of the year, it's used for entirely different functions. They just hold court one day so that they can say oldest working courthouse. Why should we be barred from it the other 364 days of the year? Thank you.
Thank you. Anybody wish to speak in opposition to this bill?
Mr. Chairman, I'm John Jones with the sheriff. We were opposed to the bill. Title 53.1 gives the sheriff the responsibility to secure the courtrooms and the courthouse. And if you allow, there's mixed use, as was brought up. You could have meetings going on in the same courthouse as a trial in another courtroom. Imagine some of these courthouses in our larger urban areas have many, many courtrooms going on at the same time. We secure the whole building. If you allow firearms to come in any circumstances, we're going to have to do a sweep to make sure there was no stashing. And no one has mentioned the courthouses, and everyone's thinking about your courthouse at home, but this would also apply to the Supreme Court of Virginia, when the Capitol Police are responsible for that security, and we all have meetings there all the time and with court going on. Thank you.
Thank you.
Mr. Chairman, Nancy Park, Commonwealth Attorney for the City of Chesapeake, here on behalf of the Virginia Association of Commonwealth Attorneys, and we oppose this legislation for all of the reasons that have been commented on. Just the thought that someone could come in and stash a firearm somewhere in our courthouse, in a bathroom or anywhere else, and then during a trial, before a trial, to to intimidate or to shoot one of our witnesses or one of our judges or one of my prosecutors or defense attorneys. Thank you.
Thank you. Yes, ma'am.
Doreen Dalton, Office of the Executive Secretary for the Supreme Court of Virginia. At this time, we do not have an official position because it has not worked its way through our process. However, we do recognize and want to raise the same security issues that have already been raised. Our General District Court judges have reviewed this bill and have voted to oppose it. Our courts of record judges are going to review it tomorrow.
All right.
Thank you.
Well, thank you for being here. Anybody else? All right. Senator Peak, bill is before us.
Move to report.
There is a motion to report.
So quiet. So quiet.
All right. I'm sorry.
Oh.
That bill fails.
All right.
And try again?
Next year.
Well, I meant,
No.
Senate Bill, you want to make a
Oh,
motion?
my next.
I'm sorry. Yeah, that's fine. Senator Norman. And-
Only because I had issued some admonitions that every bill ought to be voted on. I respectfully move that the bill be passed by indefinitely.
All right. Motion is pass bill by indefinitely. Clerk will open the roll. And I will tell you that clerk can close the roll.
Ayes 12, noes 1.
I can tell you that during my first session here, I had a bill in front of the Senate Committee on Finance. Nobody on this committee was chairman of the Finance Committee at that time, and I had a bill and presented it, and after a long pause, one member of the committee actually said, I move to report. The chairman of the Finance Committee got up out of his chair, slowly walked down to that senator, and in a stage whisper said, "What the hell do you think you're doing?" There was no second on that bill. So I hope you understand. I mean, no offense by having a vote. I think it's perfectly appropriate. Yeah. Senate Bill 350.
Let me, somebody left it. 350. Oh, this is an excellent bill. I think the committee will like this bill. This one was recommended to me by the Sheriff's Association and police, who have to do the concealed handgun permits, and they found that your concealed handgun permit people are the most law-abiding citizens in the Commonwealth, and so they're having to do them every 5 years, and it takes a lot of their time, and it's unnecessary. So they've requested that we raise it.
Senator McDougal.
Sir Pete, did you sign on to the sheriff's pay raise budget amendment?
Yes, I did.
Well, Mr. Chairman?
Yes, I
Were
did.
you planning on funding this or that?
This has no financial impact. They're doing it. It just lasts for 15 years.
Mr. Chairman?
Senator McDougal.
Well, that means the fees that are associated with the other years where they would have to be renewed, we have to account for those. So we'll look at this in a different venue, but you'll have to come up with some resources.
Senator Norman.
Mr. Chairman, I just wanted to share with Senator Peak, it may have an indirect financial impact because of the lack of fees that are going to be collected by the clerks of the courts. And I know what that's going to lead to. It may be difficult for us to quantify, with empirical data, but I know that's where the clerks of the courts will come from because of the anticipated loss of revenue. So I just offer that by way of explanation.
Mr. Chairman.
Mr. Chairman.
And Senator
Hang on.
Norman, I'll
Go
just,
ahead, Senator Pete.
some localities do not charge any fee at all. There is no requirement to charge a fee, and some localities are not charging a fee.
Senator
Mr. Chairman, just, if that is indeed the case in the finance aspect of it, I think there are those who are concealed carry permit holders would pay a little bit more to have their, not have to renew every 5 years, just.
So you want a fee increase? No, never mind. Let's, it's late in the day. I apologize. Let's hear from those who wish to speak in support of this bill.
Philip Van Cleve, VCDL. Well, I can sympathize with the clerks and so forth. This fee we're paying is supposed to cover the cost of the permit. They're not supposed to be making money on it or depending on it to feed their children. This is to cover the costs. If they're charging more than it's costing them, then we've got a hidden tax here. So I think this is a great idea, and it will save money. Thank you.
All right. Anybody else? Anybody wish to speak in opposition to this? All right, the bill's before us. All right, it's been moved and seconded the bill be reported and re-referred to the Committee on Finance. Clerk will open the roll. All right.
Ayes 13, noes 1.
Reported and re-referred to Committee on Finance. Next, we have, I'm sorry, you want to reconsider?
You want to change that?
All right, is there a motion to reconsider? It's been moved and seconded to reconsider the vote by which that reported and re-referred to Finance. All in favor signify by saying aye. Aye. All opposed? It's reconsidered. The motion is to report and re-refer to Finance. Okay.
Ayes 14, no 0.
All right. And finally, we have Senate Bill 351.
Mr. Chairman, yes, this is a bill to add our vehicles for the protection, to treat our vehicles like our homes, which we do so often. This situation, people are traveling from one place to another. They have their gun in their car. They want to go to some place that outlaws guns, and then they're going hunting afterwards. So they're in a bad situation, but as long as the vehicle is secured, the gun is secured in their vehicle, there is no danger. So it gives the protection of a home to your vehicle. And I know there had been a concern from the shipyard in John Cosgrove's Senate district, and we have taken steps to eliminate that, and I think there's not a problem with them anymore. So that's where I stand. I think I have people to speak.
So let me ask you a question.
Several questions, okay.
Is somewhat hypothetical and somewhat tongue-in-cheek, but let's say you work for a church. How about that bill that we just passed, giving churches dominion over their own property? So can you, if your bill passes, can you or can't you take a gun locked in your car to your church if your church says we don't want a gun on our property?
Mr. Chairman, I believe that this bill would allow you to have your firearm properly secured in your vehicle on the church parking lot.
Even if it has a no firearm?
Even if it has a no firearm policy, because you might go to church and then leave church to go hunting.
Mr. Chairman.
Because now that we have Sunday hunting.
All right.
Mr. Chairman, what if I put a sign on my property that says firearms are not permitted? Any person possessing a firearm and comes onto my property is trespassing. And then you come onto my property with it in your locked trunk.
I would say that this bill would overrule the trespassing because it would be properly secured in your vehicle, which would be treated as your home.
Should they be? So does that elevate your firearms rights above my property rights?
It would give, yes, as long as the firearm is properly secured in your vehicle, locked up, yes, it would. It would protect the individual's firearm rights over your parking lot rights. And this is what we're talking about, parking. We're not talking about carrying it in there or anything else. It would secure my individual Second Amendment rights over your parking lot rights.
So if instead of securing it in your locked container in your car, you leave it in a holster and go into the business,
Then
does
you
this
got,
provide any protection at all to that person?
I don't believe so, because it says secured in your vehicle, properly secured, so I think it's restricted to your vehicle, giving you the, our vehicle, we have so much, we treat them like homes, it gives the vehicle the legal effect of your home.
All right, so,
Mr. Chairman?
yeah.
What about if I live in a condo or apartment and I have a parking garage? So you've moved now off of a business into the curtilage of my home, and I have that same sign saying, anybody who comes here with a firearm is trespassing. So are you now not putting your Second Amendment rights over my property rights of my home, not of a business, but of a residence?
Yeah, and I would say, similar to where I am staying now, we have a parking garage, and I am staying in an apartment. And if I'm here during session, but I want to go hunting on the weekend, and they say no guns in those apartments, I need to keep that gun in my car in your parking lot. I submit that this statute gives my Second Amendment gun rights over your parking lot rights, because that's still parking. It's still in my vehicle. Now, if I drive my car into your house, I might be trespassing.
Do you have a line amendment?
Mr. Chairman, yes, I have two line amendments.
Okay.
One is on line 31, striking the word lawfully. So it would read, that was stored pursuant to subsection A. And then on line 34, striking vehicles on. So it's, that Romanet 2 would just read, would read property controlled by an employer required to develop and implement a security plan.
So are those technical amendments? Charles?
Those are technical amendments.
Okay. All right, Sarah Peak, you want to move those amendments?
I move those amendments.
Is there a second? It's been moved and seconded. All in favor of adopting the amendments, signify by saying aye. Aye. All opposed? Amendments are adopted. All right, anybody wish to speak in favor of this bill?
Can I ask a question?
You certainly can.
Sorry, Mr.
Don't go
Chairman.
anywhere.
I'm reading this thing and I'm trying to understand it. Paragraph A, no person, property owner, tenant, employer, business agent, maintain, establish, prohibiting a person who may lawfully possess a firearm from storing a firearm or ammunition for a firearm locked in a motor vehicle in a parking lot, parking space, or other similar property set aside for motor vehicles. So that means at my house, in my parking lot, I can't even tell you can't put your car in it if you've got a firearm in it. I think. I can't exclude you from my property because you've put a firearm in your car.
But you can exclude me.
Even if I don't like you.
Mr. Chairman, you can exclude me from your property.
No, I can't.
Yes, you can.
Can't exclude your car if it's got a gun in it.
But you can exclude me and tell me to leave. Yeah.
And you could leave your car with the gun in my parking lot. And there's not a damn thing I could do about it.
Let's see.
Now that's, I'm a property rights advocate. That gives me a little bit of trouble, Senator Pete.
Well, it does not say residence. It says in a parking lot, parking space, or other similar property. But if I understand your question, and then going similar to what Senator McDougal had said.
Mark, what are you trying to get at? I mean, are you trying to get at this situation, or are you trying to?
Yeah, what we're trying to get at, like I earlier said, Mr. Chairman, the hunting situation, for instance, or you're going out of town. So I'm traveling go see my son at Virginia Tech, and then I want to go to the National Forest to go hunting afterwards. So I go to Virginia, go to the football game, watch us beat somebody. Then I want to go to the National Forest and go hunting afterwards. Virginia Tech has a policy, no firearms properly secured in your vehicle in our parking lot. So I go, I want to tailgate, drink Coca-Cola, go to the game, then go hunting afterwards. I got to go back to Lynchburg to get my gun. That's what I'm trying to get at. That's the purpose of this bill.
Philip Van Cleve, VCDL. Yeah, when we were looking at this, we were trying to find a good way to balance out the property rights. You've got the rights of the person that owns the vehicle that's got legal things inside of it. It's like, I can't tell you what you can legally have in your house. When you're in your car, that is your temporary residence. And the things you have in there that are legal, nobody should be able to tell you if they're legal, whether you can have them or not. But if you step out of that vehicle with anything, then the private property kicks in. They say, no guns on this property, outside that vehicle, and then you can't take them out. So it's a nice balance between two sets of property rights. And again, as the senator said, if you're going somewhere and they put up a no gun sign in a parking lot and you've got no choice but to park there and you didn't know that was going to happen, now what do you do? Do you have the proverbial guns in the street where you leave it laying on the curb while you go in? You can't do that. So.
What you're trying to get at is what it sounds like you're trying to get at are areas that are open to the general public, not areas that are not open to the general public.
Well,
my driveway isn't open to the general public.
Yeah.
Certain businesses are not open to the general public. There are certain, governmental agencies. Take the secure lot of state police or, sheriff's office. That's not open to the general public. I don't think you're trying to get at those, are you?
Well, I will say, and this is
Or
a problem
maybe.
sometimes with employees, where you work for a company, you simply want to park your car, go to work, but not be disarmed to and from work where you've got to go various places. You want to just legally leave it there, you're not going to touch it, and just have it in the car. When you get off the property, then you can take it out of the trunk or unsecure it or whatever.
But, yeah, okay. I'm not going to argue. I hear you, and I don't mean to stop you, Phil.
Well, that was pretty much it.
Mr. Chairman. Phil, do you see my point in paragraph A? This bill actually takes away my ability to remove you from my property if you're a trespasser. If you read it, that's what it does. I know what you're trying to get at.
Is there an easy way to fix that if you feel that way? Is there something that jumps out at you where you can clearly tell the person, we don't want your car on my property, forget what's in it?
Paragraph A takes away my ability to have someone or their car removed as a trespasser, but just because they've got a gun in it. And I don't think
that's not necessarily, you could simply, yeah.
Read the language is what it does.
But you would tell them that, you could always tell the person to leave along with their car. But you're saying the car would have to stay. Well, can we bind it together? If the person has to leave, so does his car?
The bill does a lot more than what y'all are trying to do.
All right. I think I generally understand what you're trying to do, and I don't disagree with what you're generally trying to do. I think this bill probably needs a bit of work. With due respect. I don't want to stop anybody from getting up, although you're welcome not to. The bill is before us.
I would submit that Senator Norman has a method for handling these things.
Well, I don't think that, I don't support passing it by indefinitely. I would like to see it carried over and work on it and try and find a way to do it. So if there's a motion to pass it by for the year, we can come back and see whether we can work on it. I'm for that. All right, it's been moved and seconded to pass the bill by for the year. All in favor? Sir Peak, thank you very much.
Mr. Chairman, thank you.
All right, let me just tell you, that was the last bill. We have handled, get this, 85 bills over 2 days. We had 205 bills in the Courts of Justice Committee. We only have 120 more bills to go. 120 more bills.
Yeah, but they might get more complicated.
85 bills. The committee will rise.